Good morning. It's 9 a.m. on February 19th, 2026, and we're now on the record. This is an evidentiary hearing in proceeding number 25A-0354E, Public Service Company in Colorado's application for an order authorizing the company to construct segment 5 of its Colorado Power Pathway along the proposed route within Elbert County, Colorado. I'm Eric Blank, the Commission Chair. Can my colleagues introduce themselves for the record, starting with Commissioner Plant?
Good morning, Commissioner Tom Plant.
Good morning, Commissioner Megan Gilman.
Thank you both. With that, let's go through the entries of appearance, starting with the company.
Good morning, Commissioners. Caitlin Shields from the law firm Wilkinson Barker Nauer. With me is in-house lawyer Tyler Manschul with Excel Energy, as well as Lauren Caliendo, also from Wilkinson Barker Nauer.
Thank you. Trial staff.
Good morning, Mr. Chairman, Commissioners. Brian Krakis from the Attorney General's Office on behalf of trial staff of the Commission. With me is my co-counsel, Justin Larson.
CEO.
Good morning, Commissioners. This is Gabby Falcon from the Attorney General's Office on behalf of the Colorado Energy Office, and also with me today is my co-counsel, David Banis.
El Paso County.
I think you mean Elbert County, Commissioner.
Oh, geez, sorry. It's been a
I've
long
been confused
week.
many times myself. So thank you, Commissioners. My name is Gary Kaufman from the law firm of Beatty and Wozniak, representing Elbert County. With me is my colleague, Devin Bell.
Thank you. Kosasia.
Good morning, Mr. Chairman, Commissioners. Ellen Howard Kutzer, appearing on behalf of COSA. Thank you.
Thank you. And Commission Counsel.
Good morning, Ruth Harper of the Colorado Attorney General's Office, and with me is Lindsay Dundas, also of the Colorado Attorney General's Office.
Did I miss anyone? Shifting to electronic process. We're going to conduct this hearing using electronic exhibits. A spreadsheet marked as Hearing Exhibit 600 lists the latest versions of the pre-filed testimony and attachments. With that, any objection to the admission of Hearing Exhibit 600, the spreadsheet listing all of the exhibits? So we're not talking about the exhibits yet, just the spreadsheet. Ms. Shields.
Yes, we just had one clarification that we wanted to raise, and that was with respect to Hearing Exhibit 105, Attachment JLC 11. And we just wanted to confirm that the Commission has the entire exhibit or the entire document in the record. It appears that the linked exhibit is just the slip sheet.
Ms. Crane, Ms. Dundas, Ms. Harper.
Yeah, this is Ms. Crane. I have it and I have it ready to be pulled up.
Okay.
Wonderful.
Thanks. Any objection to the admission of Hearing Exhibit 600? Hearing none, so admitted. With that, any objection to the admission of all the pre-filed exhibits listed on Hearing Exhibit 600? Ms. Shields.
Yes, and so the company, the company is willing to stipulate to everything, except at this point, Hearing Exhibit 206. Just to provide a little context, that's the answer testimony of Elbert County witness, Mr. Christopher Price. I understand that there's some cross-examination scheduled for him. We have a couple of concerns. He was an attorney or served in a lawyer capacity for the county. Throughout the course of discovery, we asked a number of questions related to his testimony, and the county objected on attorney-client privilege grounds. And so we would simply like the opportunity to pursue cross-examination and understand whether or not Elbert County plans to restrict or limit the company's due process rights on the basis of attorney-client privilege. And so at this point, we are not necessarily objecting to the admission of that exhibit, but would like to reserve our right.
Mr. Bell, any response? It seems like we're not going to try and decide anything now. We'll just take it question by question on cross, and we're going to protect the attorney-client privilege.
No, you bring up a good point, Commissioner. I think the appropriate path forward would be to field those questions as they come during cross-examination. Obviously, Mr. Price has attorney-client privilege in terms of the communications between him and county representatives, but I don't think that's going to impact Excel's opportunity to ask him about his presence at certain meetings, his review of certain materials. But in terms of communications between him and the county, that would be subject to attorney-client privilege. And just for sake of transparency, I would make those objections.
So I guess, Ms. Shields, consider the commission warned. Commission counsel will be paying close attention to balance your due process rights with protecting attorney-client privilege for the county. And we'll just take it up objection by objection, question by question during the cross. Does that work for you?
I'm sure we will all be waiting with bated breath, but yes, that does. Thank you.
With that, any objection to the admission of hearing exhibit 600? Hearing none, so admitted. It looks like the only witness without
Sorry,
Oh,
sorry to
Ms.
interrupt.
Harper.
I think just to make the record clear, you were down on the point about admitting all of the items listed on hearing exhibit 600, with the exception of the document that Ms. Shields had mentioned. You had already admitted the exhibit.
Wait, so as far as I'm concerned, we've admitted the exhibit, Ms. Shields noted, but just recognizing on cross, we may have some issues. So is there anything that needs to change or that I missed?
Sorry, go ahead, Ms. Shields.
I was going to say, I think at this time the company, to be clear, is not stipulating to the admission of a hearing exhibit 206. We are reserving our right to object to the admission of that exhibit, but our request would be that we go through the admission process is part of his cross-examination.
All right, so we'll so all the exhibits on hearing exhibit 600 are admitted. We're going to hold that one document and not admit it until after the conclusion of cross. Is that what I'm hearing, Ms. Dundas?
Just for clarity, Chair, the document we're talking about is hearing exhibit 206, Mr. Price's answer testimony.
Yes, that's my understanding.
Okay. And the related attachments, Ms. Shield, or just 206?
That would be the related attachments as well.
Okay, so I was confused on that point. So we're not admitting 206 currently or any of the attachments. We may, and maybe we won't admit it at the beginning of Mr. Price's testimony, but we'll wait till after cross-examination, see where we're at, and then make a determination at that time. Is that an accurate summary, Ms. Shields?
Yes, that is. Thank you.
Any concerns, Mr. Bell?
Yeah, I apologize, Commissioner. Just practically speaking, and as a matter of sort of procedure, I'm not sure if admitting the testimony at the end of cross-examination makes entirely a lot of sense. I think maybe Ms. Shields can perform a voir dire type of analysis after I try to introduce Mr. Price. I'm not entirely sure if it's just communications between Mr. Price and county representatives, those would be subject to attorney-client privilege. But if she's going to be asking him substantive questions about his observations, his review of certain materials, I'm not sure if it makes entirely a lot of sense for allow her to do that. And then we decide whether or not to move his testimony into admission. I think it might make more sense for Ms. Shields to address the issues that she has with Mr. Price from the get-go, and then we can move it into admission, and then she can ask her substantive questions. But just as a matter of practicality, I'm not sure if that makes a whole lot of sense.
All right, here's my request. Let's not admit hearing exhibit 206 now, or the attachments. If counsel for the company and counsel for the county could work with commission counsel to see if you could create an effective way to get the concerns in front of us, that would be greatly appreciated, whether it's through voir dire or through just allowing for us to proceed. So if you could come up with a recommendation how best to do that, that'd be great. And I'm flying completely blind. I don't know what the objections are. So let's take that up when we put witness Price on the stand.
Will do. Thank you, Commissioner.
All right, with that, the hearing exhibits, except for 206 and the attachments, are admitted. We'll take up 206 at the time witness Price comes on, and feel our way through it, hopefully with a mutually agreeable process to flag the concerns. With that, I think all the witnesses have crossed except for witness Giblets. Commissioner Plant, do you have questions for that witness?
I do not.
Commissioner Gilman?
I do not.
Commission Counsel?
We do not. Thank you, Chair.
With that, I think Giblets may be excused. I think that's all the preliminary matters I had. Ms. Shields, Mr. Kaufman, Ms. Kutzer.
Good morning, Mr. Chair. With your permission, COSA does not have any cross-examination reserved. I would like to ask to be excused and observe the remainder of the hearing online if possible, recognizing that is at my peril.
I don't think there's too much power for you. So that would be fine. Thank you. Any other preliminary matters before we call our first witness? All right, Ms. Shields or company counsel, you want to call Mr. Lunar?
Good morning. I believe Mr. Lunar is
There he
here.
is.
Yes.
Morning.
Mr. Lunar, can you hold up your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Put your hand down. Is anybody with you or communicating with you in any way?
No.
If that changes, will you let us know?
Yes.
Back to you, Ms. Shields.
Good morning, Mr. Lunar. Could you please state your name and title for the record?
Yeah, my name is Jared Lunar, and I am a regulatory policy specialist for Public Service Company of Colorado.
And are you the same Mr. Lunar who filed direct, supplemental direct, and rebuttal testimony along with corresponding attachments in this proceeding?
Yes, I am.
And if I were to ask you those same questions today, would your answers be the same?
Yes, I would.
All right. I believe the exhibit, his testimony has all been moved into the record. So with that, the witness is available for cross-examination.
Mr. Kaufman, I have 30 minutes and it's 9:15. You're up, sir.
Thank you, Commissioner. Hi, Mr. Lunar. My name's Gary Kaufman. I'm one of the attorneys for Elbert County in this case. I just have a few questions for you, and I'd really like to start with your role in the underlying proceedings. Mr. Lunar, did you attend the Elbert County Board of Commissioners hearing on public services companies permit applications that occurred on June 24th and 25th, 2025?
I did not attend in person, but I did watch the meetings as they were being held.
Thank you. So I assume you did not participate. Is that correct?
No.
Okay, thank you. Did you attend any of the Power Pathway public outreach meetings that occurred in Elbert County?
No, I did not attend any. I did watch the commission's public meeting that was held.
Okay. But you didn't attend any of the meetings that are listed in Ms. Chester's Exhibit 102, Attachment JLC3, did you?
No, that's not my role with the company. Ms. Chester did attend those, though.
Okay, thank you. Did you attend any of the meetings with Elbert County staff regarding the Power Pathway project and public services applications for siting permits at issue in this case?
No, I did not attend those. Ms. Chester did.
Okay. And did you have any role in putting together the applications?
I think I might have been consulted on a few pieces of the application, but I was not directly responsible for developing and submitting the application.
Did you have any role in responding to concerns identified by Elbert County staff on the applications?
Yes, again, I was consulted on some of those, but I wasn't directly responsible for preparing the company's responses.
Have you ever had a conversation with any of the current Elbert County commissioners?
No.
Have you ever had a conversation with any of Elbert County staff regarding public services permit applications?
No.
Have you ever even been to Elbert County?
Yes, I have.
Oh, that's great. It's a beautiful country, isn't it?
It is.
Thank you. So turning our attention to the Power Pathways project more generally, in addition, you state in your testimony that Segment 5 runs through 6 counties in eastern Colorado: Pueblo, El Paso, Lincoln, Elbert, Douglas, and Arapahoe. Is that right?
Could you pull up my testimony to reference that? If I did mention Douglas, that might have been an oversight. I'm not certain that the project actually enters Douglas County.
Okay. Yeah, if we could pull up Hearing Exhibit 101 at page 23. So in lines 11 through 13, you do mention those 6 counties. That's correct.
Yeah, and the disconnect there might be, I think the initial study area that the company had identified for Segment 5 did include portions of Douglas County, but the specific route that the company has identified as a result of the siting process I believe, does not pass through Douglas.
Okay. So to be clear, the route does not pass through Douglas County.
That's my understanding, subject to check.
Thank you. So in addition to Elbert and El Paso counties, the company is still waiting for a land use permit for Segment 5 in Arapahoe County. Is that right?
Yes, that application is pending before the Arapahoe BOCC.
Okay. Now, you state in your testimony that completion of the Power Pathway project is needed to meet the company's 2030 emission reduction targets. Isn't that right?
Could you point me to the specific reference for that?
Yeah, if we could go to Hearing Exhibit 101, page 43. Maybe just a little further down, line 21, starting on line 21 and then running through page 44.
Yes, so that as I explained here, that is one of the reasons that the Power Pathway project was found to be needed by this commission.
Yeah, and you state that the company won't be able to interconnect with a sufficient quantity of renewable energy resources. Is that right?
Yes, the Pathway project is an essential part of the infrastructure that will deliver the resources that the company has selected and is seeking to obtain through resource plans in front of this commission.
Okay, but you would concede that there are currently no renewable resources seeking to connect to Segment 5 in Elbert County. Isn't that true?
That is not relevant to the need for the line.
I'm not asking you for your opinion on relevancy. I'm just asking if there are any projects that are currently seeking to interconnect to the Power Pathway project in Segment 5 in Elbert County.
My understanding is that the company does not have selected through a resource plan any resource located in Elbert County. However, that is not relevant to the need for the line to cross through Elbert County because of the interconnected nature of the transmission system. Okay.
So the answer is
located elsewhere will make use of this transmission capacity.
Sure, I totally understand. But at the moment, there's no resources seeking to connect to the line in Elbert County.
Not that I'm aware of.
Okay, well, that's what you say in your testimony, isn't it?
Yes.
Okay. And does your testimony identify any specific renewable energy project that will be delayed or abandoned because of Elbert County's decision to deny public services requested siting permits?
Again, the specific resources are not the issue here. The issue is the capacity of the company's transmission network.
That I understand, Mr. Elbert. I'm trying to get to specifics here, and
Yeah.
in your testimony, you do not identify any specific resources that will be delayed or abandoned because of the county's decision. Isn't that right?
Resources that are connected to the Colorado's Power Pathway will experience increased curtailment as a result
Luna,
of them not being deliverable.
Could you answer my question? I just want to know, are there any specific resources that you identify in your testimony that will not be able to, that will be delayed or abandoned because of the county's decisions?
In my testimony as written, no. However, I can
thank you.
Here on the stand that the company's resources that have been selected on the pathway project will be subject to increased curtailment as a result of this denial.
I understand that, but there's no specific resources identified, right?
Not in my testimony.
Okay. Now, the company's plan is to complete construction of segment 5 in 2027. Isn't that right?
Yes.
Does your testimony provide any information quantifying the lost emission reductions that will occur if segment 5 is not built by 2027?
No, it's not quantified.
Okay. And so, for example, you don't have any quantification about what will happen if it's delayed until construction's delayed until 2028?
No, the company has not modeled that.
Okay. And by virtue of your testimony, I'm assuming that the same is true for 2029. Is that right?
Yes.
Okay. Does your testimony provide any information quantifying the level of emissions that will occur if the PUC grants the company's application versus the level of emissions that will occur if the PUC denies the company's application?
I don't recall what references I had to in my testimony, if any, to the company's 2021 electric resource plan, but there is information in the commission's proceeding there about the emissions reductions that will be achieved through the portfolio that was approved in the 2021 ERP.
Okay, but you don't quantify specifically what will happen if the PUC grants the application versus what will happen if the PUC denies the application. Isn't that right?
No, that's not quantified here.
Okay, thank you. I don't have any other questions. Thank you, Mr. Lunar.
Thank you.
Thank you, Mr. Kaufman. Commission Counsel, any questions for Mr. Lunar?
No, Chair.
Commissioner Plank, questions for Mr. Lunar?
I do not have any questions for Mr. Lunar.
Commissioner Gilman?
Yeah, just a couple questions for you, Mr. Lunar. Good morning.
Yeah. Good morning, Commissioner Gilman.
Thanks. In your rebuttal testimony, you had indicated that the company is concerned about the commission adopting the recommended conditions and impact fee, and I believe staff witnesses are advocating for adoption of the impact fee. So can you help me understand the company's perspective? I didn't see a lot of detail in your rebuttal about that, and just wanted to understand why that was the position of the company.
Yeah, so I think, when we express concern about adopting the specific conditions that Elbert County had listed in their staff report and phrased those as being for another approving body, we have some specific substantive concerns with some of those conditions. Ms. Chester is prepared to discuss those in more significant detail. But that is the primary reason for our discussion of those conditions, is some specific substantive issues that we would have had with them, whether they be adopted by this commission or by the county. Again, that's not to say that we believe that it's improper to adopt any conditions, or there are ones that we wouldn't agree to abide by, but Ms. Chester can walk through that in more significant detail and comment on where those areas of disagreement are. With respect to the impact fee, you know, that comes down to, I believe, our ask of the commission here is not to grant, you know, step into Elbert County's shoes and grant the permit subject to Elbert County's code, but for the commission to grant the company the ability to move forward and construct. I think Elbert County's code is certainly instructive for this commission, but it's not binding on what the commission can or should approve. And the company is concerned that, you know, if Elbert County's rationale for denial is that there are impacts to the county, it had the ability to approve a permit with conditions, and it would have received this impact fee had the county approved the company's permit application. We are concerned that if the commission were to step in and grant this fee to the county of over $2 million, the county was able to, you know, frustrate and delay the execution of this very important project for the company and for the state, and not, you know, still be able to show up and have its own, you know, restrictions and requirements enforced by another entity. So the company just kind of views this as kind of a fundamental fairness issue in the permitting process of Elbert County had a route readily available to it that would have included this fee. It chose denial, and we don't believe that it's appropriate for Elbert County to deny and frustrate this project and be able to step in and impose its own code requirements at another, you know, another point in time.
Okay, thanks. And y'all probably get in with their witness as to what the impact fee is intended to cover or signify. But to the extent the impact fee is intended to try to, I guess, cover any negative or detrimental impacts or needed additional resources, does that become not true because we've gone this other route? I think that's what I kind of figure out.
I think what's interesting here is impact fees are not a given. Some counties impose them, others don't. So there are other avenues that Elbert has available, including through the payment of taxes that we will pay to the county for this project to recover the impacts. You know, I understand this is kind of a hard line that the company is taking, but again, we feel that if the county wanted to assess its impact fee, that is its fee to assess through its permitting process. And the process we're engaging now is not Elbert's permitting process, it's this commission's.
Thanks. And then I wanted to better understand the suggested fire department fee. I don't know what to call it, but I think you understand what I'm talking about.
I think it was similarly an impact fee.
Okay, versus the more broad impact fee identified by the county. Is Ms. Chester better for that, or do you have specific?
I could probably speak to it at a very high level, but Ms. Chester is much more versed in the details than I am.
Okay, I'll just go over with her, no worries. And my last question for you is around land control on the parcels that the route is proposed to cross. And I'm not sure again if I'm better off just going to Ms. Chester with this. But this is certainly an issue that seemed to strike a chord with the community, especially the impacted landowners at the public comment hearing. So I wanted to better understand the basis for the company's understanding or claims that the land control had to be secured first, including through mechanisms like taking individual landowners to court prior to the permit.
Yeah, Ms. Chester can speak to that in much more detail. It does come down to, I think, you know, conversations and feedback that the county gave us about land control and what they expected to see relative to the permitting process. But again, Ms. Chester can speak in more detail as to kind of the the relationship between those two processes and why at times they do run in parallel.
Okay, got it. I'll follow up with her. Those are my only questions. Thanks, Chairman.
Thanks, Commissioner Gilman. I just wanted to follow up with your conversation with Commissioner Gilman. If the commission does find that there are adverse impacts associated with the line, sort of consistent with the county's view, and wants to find a way to offset those impacts, any advice about the basis for doing so? I mean, is it the company's position? It can be higher or lower than the impact fee, and what's the basis for that if you're not willing to use the approach embedded in the county regulations?
Yeah, I think the evidentiary record on this in this proceeding on that issue is tough, because I think what you have is the county had the opportunity to approve this project with the impact fee that it had calculated subject to its methodology. The county did not find that fee to be adequate. I think we wouldn't be here today. If that fee offset the concerns, we wouldn't be here today. The county has not indicated to us that this is a financial issue, that the impact fee is the sticking point here. I think we've heard a lot of different things from the county, and the fee has been fairly low on the list, to be honest. So the only evidentiary record that exists here is the fee that was calculated subject to the county's methodology. Had the company approved, or had the county approved it, the company would have paid that fee without challenging it. But the county didn't approve it. So, you know, the company's position here is the commission should approve this application without the inclusion of the impact fee. The county has not taken the position that there is an impact fee level that it would find adequate to offset their concerns.
I mean, do you believe there are at least some adverse impacts to the line?
I think there certainly are impacts to the community and the county from the line. I think you need to take a holistic view of that, though, and weigh the adverse impacts and the benefits. And the benefits not just at the local level, but at the statewide level as well.
Do you know what the taxes are? I think in El Paso it was under 200,000 a year. Do you know what, or is that a Miss Chester question?
Miss Chester knows that number better than I do.
Okay. At the end of the El Paso County hearing, the company put forward hearing exhibit 122, labeled commitments for Colorado's power pathway project development. Are you generally aware of that document?
I am.
And is there a similar company prepared document on this record for Elbert County? It sounded like maybe Miss Chester was going to walk through verbally, but is there some written document that's comparable?
There is. I do not believe it is in the record in this proceeding yet, but Miss Chester is going to be prepared to discuss that with the commissioners when she comes up.
Okay. That's all I had. Ms. Shields, redirect.
Thank you. And so, Mr. Lunar, picking up at the very end there regarding this commitments, just to reaffirm your testimony is that the company has in fact prepared a similar commitments document, and Ms. Chester is prepared to walk through that document, right?
Yes.
Okay. You had some dialogue with counsel for Elbert County, Mr. Kaufman, regarding the potential implications of the county's denial on interconnecting generation resources. Do you remember that exchange?
Yes, I do.
Okay. Could you elaborate on the concerns that the company have with delaying construction of segment 5 of the pathway project due to the county's denial of the permit?
Yes, I think, the first thing I would go to there is the commission's finding of need for this project. This project has been extensively vetted through a commission litigated proceeding determining the need for this project. And the commission found that not only was it needed, but the timing of its completion was critical to the value that it would deliver to the state and to public services customers. So that's, I think, the first point I would make there. In addition, I think, Mr. Kaufman's focus on specific resources or specific emissions levels is missing the forest for the trees. The company can very clearly identify the resources that will be hamstrung if segment 5 is not completed on time. And those are the resources that are connected to the company's transmission system throughout southern and eastern Colorado. Without segment 5, significant portions of those resources, which are identified in detail in Commission Proceeding 25A-0354E, will be subject to higher levels of curtailment and not be deliverable to the company's customers. If those resources are not deliverable, that creates additional risk for system reliability, not just for public service, but for electric customers throughout the state. The state operates with a broad interconnected grid. No utility is an island. Issues that arise on one system have the potential to cascade throughout the state. And I think that's one of the critical elements that the legislature recognized when they adopted this. The need for segment 5 is not tied to any one specific resource or any specific resource located within Elbert County. It is to serve statewide interests from a broad and diverse set of generation that's spread throughout the state. Transmission simply is not a local concern in that way.
Am I remembering correctly that the Pathway project was intentionally designed as a looped configuration?
Yes, that's correct. So segment 5 is a critical element of that loop in that it creates an additional transmission path between southern Colorado and the Denver metro area. That is a constrained part of the company's system. There's a significant amount of generation centered in and around Pueblo that serves load in Denver. The transmission paths that are there were sufficient for business as usual, but the recent resource plans that this commission has been considering and approving fundamentally change how the grid operates in this state. Segment 5 is one of those foundational elements, and without it, there will be insufficient transmission capacity to make use of the resources that are being acquired.
And Mr. Kaufman was asking some questions specifically about whether or not there are any resources, you're aware of any resources currently seeking to interconnect in Elbert County. Am I correct? The company currently has at least one, perhaps more dockets pending that relate to the ongoing evaluation of acquisition of new generation resources. Is that right?
Yes, there are two primary proceedings, 25A-0354E, which is the company's 21 Electric Resource Plan and Clean Energy Plan. There's an additional resource solicitation under consideration through that now called the near-term procurement, which is designed to seek the renewable tax credit benefits for Colorado consumers before they expire. And then there is the 24A-0454E, I believe, Just Transition Plan, which is also intended to continue the transition towards clean energy while making communities whole that are seeing retirements of generation. And I think to add to that, in addition to commission resource proceedings, the company also has an open access transmission tariff governed by the Federal Energy Regulatory Commission. any generator can request and obtain interconnection service on a non-discriminatory basis from the company. I'm aware of one interconnection request along segment 5. My understanding from the company's public interconnection queue is that project is located in El Paso County. But again, there are a lot of opportunities for resources to be developed through numerous ongoing proceedings by utilities that can seek open access to the pathway project that don't run resource plans in front of the commission. I think focusing on specific resources that may or may not be delayed is, again, missing the significant, nature of how the transmission system works.
So thank you. And so just to make sure that I understand and clarify here, given some of the ongoing and pending resource acquisition dockets, would you say that it is likely, if not conceivable, that there will be additional generation resources looking to interconnect along the pathway project and perhaps even in Elbert County as a result of the outcome of those resource plans?
I'd object that that's calling for speculation.
Calling for.
Can you repeat the question, Ms. Shields?
Yes. So to clarify, what I heard from you, Mr. Lunar, is there are several ongoing resource plans that will involve resource solicitations for the company to bring new generation resources online. Is that correct?
Yes.
And in your professional judgment and experience, do you think that it is likely that there will be generators who are interested in interconnecting to the pathway project in segment 5 or Elbert County to support the company's ongoing resource planning efforts?
And I would renew the objection. He's speculating on what somebody else might do. This whole line of questioning, Mr. Lunar didn't include any of this information in his testimony. He's trying to bolster his testimony well beyond what he's provided to the commission and not giving Elbert County a sufficient time to explore the specifics of this testimony. He's essentially trying to submit a whole new answer here.
Ms. Shields, would you like to respond?
Yeah, I mean, the company's resource planning process is a fairly speculative endeavor in and of itself. And were it not a speculative endeavor, I would guess that half the people on this call would be out of jobs. So, I think Mr. Lunar is a, policy professional who is involved in the company's resource planning and commission efforts, is absolutely capable of speaking to the potential for resources and what sort of transmission assets they might very well would be looking to interconnect to support the company's resource planning efforts and procurement efforts.
I think, Ms. Dundas, I'd probably sustain the objection and not go too far down this path. Do you have any advice?
I think that's a fine ruling, Chair, if you want to cut off the discussion Ms. Shields attempting to have about effects of this project on future applications and resource acquisition.
Yeah, I'm gonna try and keep this narrow, Ms. Shields, so I'll sustain the objection.
Understood. Well, I will help keep it focused as well. I think those are all the questions that I have for Mr. Lunar.
Thank you, Mr. Lunar. You may be excused. Ms. Chester, are you
Yes,
out
we
there?
need one quick moment on our end for technology.
Okay.
Thank you for indulging us. Just doing a quick test so that you can see and hear me.
We can see and hear you. Ms. Chester, can you hold up your right hand?
I sure can. Ooh, make sure
Do you,
there we go.
we can hear you. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Put your hand down. Is anybody with you or communicating with you in any way?
They are not, no.
If that changes, will you let us know?
I will.
Back to you, Ms. Caliendo.
Thank you. Good morning, Ms. Chester. Please state and spell your name for the record.
Sure. It is Jennifer Chester, JenniferChester.
And by whom are you employed and in what capacity?
Excel Energy Services as Senior Manager over our Siting and Land Rates Department, here today representing Public Service Company of Colorado.
And did you cause to be filed in this proceeding hearing exhibit 102, which is your direct testimony, and hearing exhibit 105, which is your rebuttal testimony?
Yes, I did.
And if I asked you those same questions today, would your answers be the same?
They would.
And as Ms. Chester's direct and rebuttal testimony have been admitted, the witness is available for cross-examination.
Mr. Bell.
Ms. Chester, how are you, ma'am?
Doing well, thank you. Good morning.
I am not sure if we've ever met, but my name is Devin, and I'm one of the attorneys that represents Elbert County in this matter. I unfortunately have a lot of material to go through with you, so let me or the commissioners know if you need to take a break, okay?
Sounds good, thank you.
My questions, I will be pulling up quite a bit of exhibits as well, so let me know if you can't see a particular exhibit when it's pulled up. I just want to be sure that you're able to see it, okay? Also, it's very possible that I could ask a very poorly worded question. So in the event that I do that, please don't hesitate to ask me to re-ask it or rephrase it, okay?
Will do, thank you.
So let's jump right into it, Ms. Chester. I'd first like to go over kind of a general timeline in relation to Excel's 2 applications submitted to the county, specifically its 1041 and its SUR permit applications. To start on that vein, in your rebuttal testimony, you testified that the purpose of a 1041 and SUR permit applications is not to present a menu of options to Elbert County Board of County Commissioners to select from, or rather, the company must present a fully developed and detailed project, including the proposed route for a significant project, like a transmission line that crosses through multiple counties. Is that accurate so far?
That's correct.
In fact, you had previously testified in your direct direct testimony that Excel had in fact provided complete applications with all of the information required by Elbert County's code necessary for the Elbert County Board of County Commissioners to adequately review and consider both the 1041 and SUR applications. So far, so good?
That's also correct, yes.
Okay, well, let's go to the timeline. So on July 11th, 2023, Excel submitted its pre-application packet to the county. Does that sound right?
We can certainly pull up that attachment, but I believe that's the correct date, yes.
Absolutely, and thank you very much for pointing that out. Can we pull up hearing exhibit 206? Well, Can we pull up hearing exhibit 206 attachment CP-1? Ms. Chester, I have just put in front of you what will be referred to as hearing exhibit 206 attachment CP-1. The reason for my hesitation is that your attorneys have objected to Mr. Price's answered testimony. I'm hoping maybe we can stipulate to this attachment. Does this document appear familiar to you?
The document does appear familiar. I would suggest I also have attached to my testimony the application package as well.
Yeah, do you know, I don't have it in front of me, and maybe that's an easier way to do this. Do you recall the attachment number that we can pull up? I'm sorry, go ahead.
Council, I have it. It's attachment JLC 28.
Let's do it that way. Make it easier, right? Okay. Now, this is hearing exhibit 105, attachment JLC 28. Thank you very much, Ms. Caliendo. I do appreciate it. Is this the pre-application packet that was submitted to the county?
It's the first page. I assume looking at the remainder of the pages, yes, that's the complete package.
And in this pre-application packet, although I don't, can we go to, Ms. Caliendo, do you know if the PowerPoint presentation was attached to Ms. Chester's testimony? I apologize. I was not expecting this.
I am not certain. I mean, we can scroll through this document and I can review her other attachments for the presentations.
Well, let's do it this way. Do you recall that Excel prepared a PowerPoint presentation for Elbert County during a pre-application meeting?
I do, yes.
Okay. And in that presentation, Excel had indicated that it anticipated to submit its applications by Q4 2023. Do you recall that?
I don't recall that date specifically, but it's possible that we were hopeful that we'd be able to do that, yes.
If I pull up the PowerPoint presentation, would that help refresh your recollection as to what Excel communicated to Elbert County?
Not sure if it's necessary in terms of the remainder of the questions that you have.
Yeah, I just want to pin this one down. So can we pull up hearing exhibit 206, attachment CP1, please? I apologize for jumping around. All right, could we go to page 30? Okay. Does this appear to be the beginning first slide of the PowerPoint presentation that Excel presented to Elbert County at a pre-application meeting in July of 2023?
Yeah, it appears so.
Okay, can we go to page 37, the last page, please? And just to refresh your recollection, Ms. Chester, in the middle of this, which is the last page of the PowerPoint slide, it says application. It says that Excel anticipates submitting in Q4 2023. So far, so good?
Yep, that is what it says.
Can we also go to page 35, please? Now, the county and the company met for a pre-application meeting on July 25th, 2023, right?
That's correct.
And during this meeting, the county and the company generally discussed the route for the portion of segment 5 going through Elbert County that Excel had selected. So far, so good?
That's correct.
And this is what I have in front of you is page 35 of attachment CP1, which is a part of the PowerPoint presentation presented to Elbert County. Specifically, this is an image of the preferred route that the company had selected, as it is represented by a green line. Is that accurate?
Yes, I believe so. It's a map that's also in our routing study. So
absolutely, that's a very intuitive question, and we'll get back to that. But the company had selected this green route at the end of 2022. Is that right?
That's correct, yes.
And at that point, during this pre-application meeting, the county asked Excel questions to get more information on this route. Fair to say?
Yes, as it was submitted in the pre-application package.
The county at that time also addressed information that it thought it was missing from the pre-application materials, including missing comments from the fire districts. Is that right?
I'm not sure which communication you're referring to. If we want to bring that up on screen, happy to look at that.
Absolutely. Would you mind pulling up hearing exhibit 105 JLC -15, please? Thank you so much. Ms. Chester, I've just put in front of you hearing exhibit 105 attachment JLC 15, which was attached to your rebuttal testimony. Do you recall this document?
I do, yes.
Now, these are the pre-application meeting notes and agenda from the July 25th, 2023 pre-application meeting, right?
That is an agenda that we created for the pre-application meeting. Yes.
Great. I apologize. I didn't mean to interrupt you, Ms. Chester. Please go ahead.
Yeah, this page is just the agenda front page. So I believe also the notes are in here later in subsequent pages.
Fair enough. Can we go to page 4, please? Now, on this page of this packet, underneath where it says pre-app comments, do you see where I'm referring? Can you read this page okay?
Yes, I can.
Okay, I think it's the 6th bullet down. It says fire districts. No comments received at this time. Please reach out to individual fire districts as listed below for more information. It provides several different fire districts, including Big Sandy / Simla, as well as Kiowa Fire Protection District. Is that right?
Yes.
Okay. So at this time, the county expressed that it wanted the company to reach out to these fire districts, right?
I wouldn't say that's exactly correct. This pre-app comments page, as you can see for fire districts and others, indicate that the county did not receive any comments from fire districts listed here. And as kind of a standard matter of course, provided contact information for the fire districts listed there. I don't see on this page that there is a concern raised or a suggestion that they needed something related to that.
Yeah, but the way that it's phrased is please reach out to individual fire districts, right?
The rest of the sentence as listed below for more information is related to the comments that would have been received. The way that these pre-app comment documents work is if a referral agency provides a comment and we'd like to follow up with them, contact information is provided. In this instance, there were no fire districts that provided comments.
Okay. Following this meeting, the county and the company exchanged letters, right?
Yes, I believe so.
Can we pull up hearing exhibit 206, attachment CP-2? Ms. Chester, I have just put in front of you what will be referred to as hearing exhibit 206, attachment CP-2. Do you recognize this document?
Yes, I do.
Okay. This document is dated July 31st, 2023 and is addressed to you. Is that right?
It is. That's correct.
And is that your correct email address up top?
Yes, that looks correct.
Okay. In this letter sent from Elbert County to you, it memorializes the county's concerns with the materials that Excel had presented to it thus far. Specifically, if we look at the 3rd paragraph, it says the county needs additional information to better understand the project, as well as to inform Excel of the materials that will be required as part of the application. Did I read that sentence accurately?
I believe so, yes.
Okay. If we could scroll down a little bit on the same page. On the 4th paragraph, Excel indicates and requests that Excel submit a revised map showing the proposed location of each tower, concrete batch plant, and laydown yard that will be a part of the project in Elbert County. The map detail should identify the height of each tower and show the zoning of the existing land, the relationship of the proposed land uses to wetlands, floodplains, and floodways, and include sufficient detail for the county to identify the proximity of the proposed uses to roads and structures. Further, we are requesting an overlay of all impacted property owners depicting where each pole will be placed and on whose land. Did I read that paragraph accurately?
Yes, and we responded to the county's request on that.
Very intuitive, because that's where I'm going right next, Ms. Chester. So can we pull up 206 CP3, please? Ms. Chester, is this the letter that you just referred to in responding to the July 31st, 2023 letter?
Yes, that looks correct. Yes.
Can we scroll to the second page, please? That is your signature and signature block at the bottom. Is that right?
It is, yes.
Can we go back up to the first page, please? Thank you. In this letter, if we look at the third paragraph, thank you very much. You indicated that Excel understood for the county's need for additional information, right?
Mm-hmm.
Is that a yes?
Yep.
I'm sorry, is that a yes?
Yes, that's what it says.
I'm sorry. You also assured the county that Excel's final application will include, as you put it, considerably more information along the lines of what you requested in your letter. Is that accurate?
Yes, that's what it says.
And that includes a very detailed siting study associated with the project and more detailed mapping. So far, so good?
Yes.
It also indicated, or excuse me, you also indicated that information regarding preliminary locations of each tower, concrete batch plant, and lay down yards, right?
Yes.
But you indicated that Excel would not be able to provide this information in its pre-application materials because it does not typically acquire all of the easements necessary for the transmission lines construction ahead of permitting. Is that accurate?
That's correct. As noted, some of the landowners in Elbert County did not engage with us at this time. So we were not able to get the rights to do that.
Gotcha. Can we go to the second page, please? Thank you. You indicated that Excel could not respond with the level of detail requested in Elbert County's letter because Excel had not obtained all of the necessary easements. Is that right?
I think we're summarizing a few different sentences that are related. So I think that generally what we indicated here is that because we did not have land rights to access all of the properties, we could not provide some of the information that they were looking for and would provide as much as possible in the 1041 and SUR applications.
Gotcha. We can take this exhibit down. So even though the pre-application presentation indicated that Excel would submit its applications by Q4 2023, Excel didn't submit its applications until November 7th, 2024. Isn't that right?
The PowerPoint that you brought up before didn't commit. It said anticipated Q4.
Sure, but
as noted, they weren't submitted by then.
Sure, but the company represented to the county during the pre-application meeting that it anticipated to submit its applications by Q4 2023, but didn't do so until November 24. Is that right?
That's correct. We anticipated and then submitted them in 2024. Correct.
So we'll get into it later, believe me, but of the materials in the application packet, the company did not provide signed fire prevention and safety agreement forms from Kiowa or Big Sandy Fire Protection Districts. Is that right?
I'm sorry, in which package?
The application materials that were submitted to the county on November 7th, 2024, those did not include signed fire prevention and safety agreement forms from Kiowa and Big Sandy. Is that right?
That's correct.
Okay. On December 30th, 2024 and January 30th, 2025, Elbert County sent XL preliminary review letters of XL's applications. Does that sound right?
Yes, that does.
Can we pull up hearing exhibit 200, attachment SAB-2, please? Ms. Chester, I've just put in front of you what will be referred to as hearing exhibit 200, attachment SAB-2. You indicated that you did recall receiving preliminary review letters from XL. Does this letter that's in front of you appear to be one of those letters?
Just to clarify, I indicated I recalled receiving letters from Elbert to Excel. Yes.
What did I say?
From Excel.
My apologies. My apologies. Thank you for clarifying.
Yep.
So in these letters, now this is a letter. Can we scroll down, please? Thank you so much. Now in this letter, the county indicated that it deemed both applications to be incomplete. Is that your recollection as well?
No, I believe this letter was specific to the 1041. The county was actually delinquent in providing completeness review of the special use application. We did not receive that until later in January. So I don't believe this says both are incomplete.
Okay, well, let's focus on this one, right? So in this paragraph in the middle that starts with the county 1041 regulations, you see that?
I do.
Is that a yes? I'm sorry.
As I just said, yes, I do.
In the middle, it says after conducting the completeness review, the application is deemed incomplete.
The 1041 application, yes.
Right. If we go further, it says the attached technical memorandum identifies each submission requirement under the county 1041 regulations, whether it is complete, and if not, the deficiencies and descriptions of additional information that must be supplied by the applicant. Did I read that correctly?
Yes.
Okay. Can we go to the next page, please? Now, this is the technical memorandum that was just referred in that letter. It is prepared by SWCA Environmental Consultants. You were aware that Elbert County had hired SWCA to help review XL's applications, is that right?
Yes, we were aware.
Okay. And in this memorandum, SWCA identified several areas where XL's application was incomplete, but I'll just focus on a couple. Can we go to page 6 of the PDF, please? Okay. Underneath where it says J.11, 1041 application regarding information describing the project. Can you see that clearly?
Yes, I do see that.
SWCA on behalf of Elbert County found that this section was incomplete. Specifically, the county found that information it had requested previously was still missing, specifically by requesting the company to provide mapping with sufficient detail to determine proposed locations of temporary construction areas. That's the first line underneath incomplete. Did I read that correctly?
Yes, I believe you read that correctly.
Okay. If we go to the next line, it asked the company to provide mapping with sufficient detail to determine proposed landowners and parcel numbers to be crossed and permanently impacted. Did I read that correctly?
Yes.
Can we scroll down a little bit, please? Thank you. The county went on to ask for current information on the number of easements that had been acquired, how many easements are still needed, and how many condemnations were anticipated. It asked the company to provide mapping with sufficient detail of estimated locations of pole construction near residential housing, as well as mapping with sufficient detail of estimated proposed landowners and parcel numbers. I can go on, but you understand that the county at this point was identifying missing information from the company, right?
To which we responded and pointed them to the locations in our application materials where that information was provided.
Sure. Can we go to page 9, please? Thank you. Can we scroll down a little bit, please? Perfect. Great. Thank you so much. Yeah, this technical memorandum goes on to identify additional information that was still missing from the application. Specifically, it first identified underneath J15 local government services, that large-scale infrastructure projects inherently increase demand for public safety services, particularly regarding fire prevention, emergency response, and ongoing maintenance of critical infrastructure. To address this, Elbert County requested Excel to provide the following, which included information on the coordination efforts to date with Elbert County emergency responders and special fire district personnel, and provide proposed work plans between local fire departments. And Excel should, I'm assuming that should say submit an emergency, or excuse me, Excel should face an emergency situation arising during the project construction activities. It further asked for an analysis of impacts to schools and a detailed traffic plan during construction. When you received this letter, did you recognize that the county was taking the position that this information was missing?
Again, we responded and provided information or pointed to the direction of where it was in our application materials. Some of the county's comments here, unfortunately, were incorrect because they were only reviewing one of the packages of information submitted to them and not the other.
Okay. So then, but regardless, Excel was aware that the county was missing information at this point, right?
Absolutely.
So then the company attended the Elbert County Planning Commission hearings on June 3rd and 4th, 2025. Does that sound accurate?
That's correct.
Okay, and you were actually present at those hearings, right?
I was.
So you have a better recollection than anyone, but at the end, the Planning Commission ultimately found that the company's applications were incomplete, right?
The Planning Commission?
Excuse me. Yeah, the Planning Commission.
Planning Commission.
I'm sorry?
I just wanted to clarify, you're talking about the Planning Commission versus staff.
Yes.
Okay.
Yes, ma'am. Yes, ma'am. The Planning Commission ultimately found that the applications were complete, right?
That's what they stated, yes.
Okay. They actually articulated that they deemed it incomplete because they lacked required fire safety agreements and they left key agency concerns unanswered. Is that right?
Yes, those are definitely points of contention with that decision.
And so ultimately the Planning Commission recommended denial of the applications, right?
That's correct.
Okay. The parties then participated in a hearing before the Board of County Commissioners on June 24th, 2025, right?
That was the first day, yes.
Okay. But the county never issued a verification deeming the company's applications to be complete before the company attended that hearing before the Board of County Commissioners, right?
That's correct.
So Excel elected to proceed forward despite not getting that completeness verification. Is that right?
Per the timeline extension agreement that was agreed upon and negotiated with the county, yes, because they did not properly process applications and provide completeness review of the SUR application.
Sure, and you brought that up a couple times, but the reason for the company and the county entering into an extension agreement was to rectify that. Isn't that right?
It was, which included deadlines to hold hearings.
But ultimately it didn't, I am so sorry. I did not mean to interrupt you. But ultimately, that wasn't an issue when Excel attended the hearing before the Board of County Commissioners, right?
I'm sorry, what wasn't an issue?
The issue regarding the extension as well as the review of the SUR application, you guys had entered into an agreement so that it was no longer an issue by the time that the company attended the Board of County Commissioners hearing. Isn't that right?
The extension agreement was to rectify that, yes. And it also set forth dates by which hearings would be held.
Okay. Following the hearing with the Board of County Commissioners, the board issued its resolution on July 3rd, 2025, at which point the board denied Excel's applications, right?
Just want to look at the date on that. I thought it was the 2nd, but 2nd or 3rd of July sounds correct.
You know, you may be right. Let's pull up a document just to confirm really quick. Can we pull up hearing exhibit 102 attachment JLC 9, please? Okay. Does this appear to be one of the Elbert County resolutions that was issued following the hearing?
Yes.
Okay. Can we scroll down, please, to page 4? Perfect. So in denying the applications, the board highlighted that it was still missing several pieces of information. For example, if we look at subsection H, it says the applicant failed to adequately address wildfire risk in its application and has not submitted analysis of existing firefighting infrastructure or estimated fire risk and behavior analysis. Did I read that correctly?
Yes, you did.
It goes on further to say that this concern was supported by testimony from a consultant hired by Big Sandy Fire Protection District to inform the board that the risk was significant. The applicant's wildfire mitigation plan was based on a statewide plan that changed while the county was reviewing the application. The applicant's Elbert County specific plan did not incorporate recommendations from the districts or Elbert County Office of Emergency Management. Did I read that correctly?
Yes.
To support this, if we go to paragraph I, it further indicates that Excel failed to work with the districts, the fire districts, that is, before submitting the application and its wildfire mitigation plan remains insufficient. Did I read that correctly?
Yes.
Okay. Can we also go to subsection K, please? In this subsection, it says several property owners raised concerns during the public hearing about the actual impact to their property from the project because they did not know whether their property would have a pole or just transmission line aerial easement. The applicant stated during the public hearing that pole locations were not yet finalized, but the applicant submitted a modified attachment N to the SUR application this year that shows proposed pole locations. However, it could not have adequately studied actual impacts from the project if the applicant remains uncertain where poles will actually be located. Did I read that correctly?
Yes. However, it doesn't represent what the applicant stated during the public hearing. If you
Okay, well, that might, sure, that may be, Ms. Chester, but at this time, again, the county is being consistent by identifying that it is missing information from Excel. Is that right?
Is it being consistent in identifying that it's missing information? Yes. However, the information suggested here that was missing was not in fact missing.
Okay, so we can take this exhibit down, please. Thank you. So in light of this resolution, I'd like to shift gears to the company's outreach with local fire divisions. I promised we were going to get there, so I'm hoping that I uphold my promise. But as part of the application process, it's standard for Excel to work with local fire divisions on its construction projects, right?
It is.
Okay, and that's important because, and you would agree that working with local fire divisions is important, especially for a transmission line as big as the Pathway project, right?
Yeah, our construction contractors, for example, engaged with fire departments and fire districts as we approach construction.
Sure, and that makes sense. I'm so sorry, Ms. Chester, I didn't mean to interrupt you. Did you have something else to say?
No, continue, please.
Okay, because it's practical, right? The company's collaboration with local fire divisions allows the company and the fire divisions to exchange information about a particular project, right?
Yes.
And it's an opportunity for the company and the fire divisions to work hand in hand to ensure that new developments, such as segment 5, have adequate, verified, and contracted emergency services to mitigate wildfire risks. So far, so good?
I would disagree with the statement regarding contracted services. It's not typical that we contract services when projects are within fire districts that exist and already serve the area, because we're not purchasing property as part of the project in Elbert County or in any other location. Those areas are already served and covered by fire districts because we're not changing the underlying land ownership.
Sure, and I really appreciate that for that clarification. So let me try to re-ask it just in a good way. But it's important for them to work hand in hand so that the company and the fire divisions can ensure that there is adequate and verified services to mitigate a potential wildfire risk, right?
Yes. And Excel was working with those fire districts and OEMs.
Oh, we'll get to the specifics. I'm just talking very generally why it's important to work with local fire districts. But in other words, it's a way for the local fire divisions to confirm that it has adequate personnel, equipment, and materials to potentially respond to a wildfire risk. Is that right?
In general, sure. Yeah.
And it's also an opportunity for the company to provide the fire divisions information on the company's safety efforts, right?
I think that's a little broad in terms of defined safety efforts or whatever, but
Absolutely. Let me try to make it a little more specific. Such safety efforts could include the potential installation and use of cameras, right?
no, I think we're straying far from what engagement might be or what we're describing. If you're trying to link fire district forums and discussions about cameras, those are very different things and very different engagement by the company. So
yeah, we're not there yet with the forms. I'm just talking very generally that it's important for the company to talk with the fire division so that the company can outline what sort of technologies it has in order to potentially combat a wildfire risk. Is that fair?
I think that questions related to wildfire risk are probably better suited to our next witness, Mr. Koretich.
And I appreciate that, but I'm asking you, and I'll be sure to ask Mr. Koretich as well. But as you're sitting here, is that kind of exchange of information between the company and the local fire divisions, is that important at least a preliminary stage?
It is important. The timing of which I think is relevant here in the line of questioning to both the work that the company conducted and outreach and engagement related to our wildfire mitigation plan that really addresses the wildfire risk that I think you're talking about.
Okay. And so part of the process between the company and fire divisions could include the discussion of paying impact fees. Is that right?
No, generally that's not the case. Across the fire districts that we've worked with on the rest of Pathway, I would say that is definitely not been a topic of discussion.
Okay. So these efforts that we just walked through, the collaboration efforts between the company and the fire divisions, those are even more important for a fire division that's volunteer-based. Would you agree?
Similar to most of Pathway, we engaged with rural volunteer fire districts as we approached construction.
Yeah, that really wasn't my question, though. My question was the importance of collaborating with local fire divisions is even more important with a volunteer-based fire division. The reason being is that they're not fully staffed with professional firefighters. Isn't that right?
I can't speak to what fire districts have staffed or not, whether they're volunteer or other. You asked if we engage with them. Yes, we do. As we approach construction, whether that's our construction team, You asked if I felt it was important to engage with them. Yes, absolutely. The company does that through a number of avenues. I can't speak to what fire districts have staff for.
As a volunteer, in your experience, and you have a vast experience working with large projects like this, but in your experience, a volunteer-based fire division probably doesn't have the number of personnel as, let's say, a fully staffed fire division, let's say in Boulder County.
Again, I can't speak to any personnel numbers. Fire districts obtain resources in a number of ways through mutual aid agreements and other things. So I don't know how that impacts staffing levels though.
Sure. So turning to, Elbert County now, to reflect that those efforts have been undergone, this collaborative effort between the company and the local fire divisions, an applicant like XL was asked to sign fire protection and safety agreement forms. Is that right?
Yes, as the applicant, we sign those forms along with the fire districts, correct?
Okay. Fire protection and safety agreement forms is pretty, it's a mouthful. Are you okay if I refer to it as like fire protection forms or fire forms?
Sure, I don't have a preference for what we
thanks. I appreciate it. Now those fire forms also need to be countersigned by the local fire divisions, right?
That's correct. In the case of the Elbert County forms specifically, yes.
Yeah, and by signing those forms, the fire divisions are confirming that they have worked with the company and have determined that there are adequate emergency services available to mitigate or otherwise address a potential wildfire risk. Isn't that right?
If we'd like to bring up one of the forms, we can confirm. It's a pretty brief statement that's on the form that the signatures represent.
I appreciate that. But as you're sitting there right now, and based on your recollection and involvement with this project, signing those forms reflects that the company and the local fire divisions had actually engaged in a collaborative process. Fair to say?
Objection, asked and answered.
Can you repeat the question, Mr. Bell?
Yeah. I think to Ms. Caliendo's point, I believe Ms. Chester testified in the affirmative on that point. So I'm happy to move on.
No, I'm sorry, that's mischaracterizing Ms. Chester's response.
Okay. So I guess I will re-ask it, Commissioner. So by the fire division countersigning these fire forms, it reflects that the fire divisions are satisfied with the collaborative process that the company has engaged with the local fire divisions in terms of addressing adequate emergency services available to mitigate a potential wildfire. Isn't that right?
I don't agree that that's the form, what the form says.
I'm sorry, I did not hear the entirety of your testimony. Could you say that one more time for me, please?
Yeah, I don't agree that that's what the form says.
Okay. So going back, in this case, and as a reminder, the company first met with county representatives in 2021 to introduce the Pathway Project. Is that right?
That's correct, yes.
Okay. Actually, you provide a really good exhibit that I think can help us. Can we pull up hearing exhibit 102 attachment JLC 3, please? So, Ms. Chester, I've just put in front of you hearing exhibit 102 JLC 3. I think it's a good 1,000-foot view of the kind of meetings that XL had with the county. So consistent with my prior question, it looks like on March 2nd, 2021, I'm sorry, I was looking at the wrong bullet point. On July 15th, the bullet point down, XL met with Elbert County representatives to provide an introduction to the Pathway Project. So far, so good?
That's correct, yes.
And then going off of this, it looks like the county met an additional 3 times with XL throughout 2023, right?
Yeah, those were meetings that we held specifically with county staff. County staff attended other public meetings and community meetings that we had between those.
Yeah, but I am so sorry to interrupt you, Ms. Chester. Right. So these are just identifying meetings with Elbert County staff. This doesn't include the public outreach meetings that you had. So you met county staff 3 times in 2023. You then submitted the application materials in November 2024. But Excel didn't successfully contact local fire districts, including Big Sandy, until March or April of 2025. Isn't that right?
Specifically regarding the forms that we've been referencing, yes, the company engaged with county OEMs and others as part of other outreach efforts related to wildfire mitigation planning and those sorts of things. But specifically related to the fire district forms, there was that outreach, as we described in our application response materials.
Sure. And once finally in contact with the local fire districts, the company primarily corresponded with and worked with 3 particular fire divisions regarding the proof of fire safety, right? That's Tri-County, Kiowa, and Big Sandy. Is that accurate?
I believe that's correct, yes.
Okay. And the company is aware that Tri-County, Kiowa, and Big Sandy are volunteer-based, right?
Yes.
And it's undisputed that the company never submitted completed fire prevention and safety agreement forms from Kiowa and Big Sandy, right?
That's correct.
And actually in the county's resolution, the Board of County Commissioners actually highlighted that it was missing those materials, right?
Yes.
It further outlined that Excel had not worked with local fire districts before submitting its applications. Do you recall reviewing that when we looked at the resolutions?
Yes, an incorrect statement, but I recall that it was made, yes.
Sure. And in addressing this issue and stemming from your disagreement, you testified that the fire prevention and safety forms do not provide any additional information necessary for the board to make a decision. Is that right?
Yes, I believe that was in our response.
Okay, but we just went over that those forms reflect the collaborative efforts between the company and the local fire divisions, right?
I did not agree that that's what those forms represent.
Okay. Now, the company takes the stance that it can't force fire divisions to sign these fire safety forms. Isn't that right?
Correct. Their signatures are voluntary on their part.
Okay. You understand that the company understands, though, that the county and its staff also can't force a fire division to sign these forms, right?
Correct, which is why at BOCC hearing, we suggested that it could be a condition of approval of the permit application that we would continue to work with the fire districts to obtain those forms.
Sure. And I know you disagree with it, but you understand that without a completed form, the county is without verification that the company and the fire divisions collaborated and addressed the potential fire mitigations needed for that project, right?
Again, not agreeing that that's the intent of the forms or fire district signature on the forms.
So another issue was in relation to the wildfire mitigation plan that was submitted along with the application materials. The company is aware, just going through the resolution, that the county believes that the wildfire mitigation plan submitted by the company was deficient, right?
I'm sorry, could you ask that question again?
Yeah, and I apologize. That was a very long-winded question. The company understands that the county views the wildfire mitigation plan submitted to it as deficient, right?
I think I need for you to confirm which wildfire plan you're talking about and which particular comment you're referencing.
Okay, just very generally, just based on the resolution. I'm happy to pull up the resolution again, but based on the county's resolution, it addressed the deficiency of the wildfire mitigation plan submitted to it. Agreed?
It stated such, but did not provide detail regarding deficiency.
Okay, so this was, yeah, and this was actually communicated to the company during the pre-application process, right?
I don't believe so, no.
Okay. Can we pull up hearing exhibit 200, SAB 3, please? Now, Ms. Chester, we've looked at this exhibit before. Just a reminder, this is the letter that was sent from the county addressed to you following the pre-application meeting. And in this, I'm sorry, go.
This doesn't appear to be the pre-application letter. Just want to make sure we're all looking at the right document.
No, and I apologize. This was the letter following the pre-application meeting, right?
Does not appear so. January 30th, 2025 would have been.
You're right.
Related to the application material.
Can we go to page 10, please? Can we go to subsection G, please? Bear with me just a moment, Ms. Chester. I apologize. You're right. This is a letter that was following the letter following the submission of Excel's applications, right? So this was a letter regarding the completeness. Is that fair to say? And we can go back to the first page just to make it clear if that works for you.
Happy to go back to the first page, but I believe that's what this letter is. Yes.
Okay. I think we can stay on this page. And in this letter, after doing a completeness review, in subsection G, it again iterates that there is missing information and that the county considered this portion of the company's application to be incomplete, right?
Yeah, this was the initial submittal, again, to which we responded.
Yeah, specifically if we go underneath incomplete, it says insufficient information provided to assess potential risks and impacts from wildfire in the event the project infrastructure results in a future wildfire event. The applicant has not submitted information on the Xcel Energy Wildfire Mitigation Program, has not created a project wildfire mitigation plan, has not met with local fire district and emergency responders, and has not provided information on wildfire mitigation technology that will be incorporated into the project. Did I read that correctly?
Read correctly. The statement is incorrect, however.
Okay.
Because we had provided our wildfire mitigation plan in our original application submittals as demonstrated in our responses to these completeness.
Sure, and I appreciate that. I was just asking if I read that correctly, but I do appreciate the additional context. Now, if we focus on the payment of certain impact fees, I guess the company argues that Kiowa and Big Sandy wouldn't sign the fire prevention forms because of the payment of certain impact fees. Is that right?
Certainly in the instance of Big Sandy had responded regarding the forms that they would sign them once the permit was approved by the county. So that was their initial response on the form. A subsequent response changed their messaging to indicate then they would pay or sign the form upon payment of fees that they had recently implemented with the county.
So are there still pending fees that the company has not paid because it disagrees with certain impact fees?
Probably need some clarity on that question.
Yeah, are there
specifically to who or what agency?
Yeah, I guess in relation to Big Sandy or Kiowa, are there application fees or impact fees that the company has not paid because they view it's too much?
Yeah, as stated in our responses to Big Sandy's comments, which were actually provided to Elbert County, we did respond and indicate that we did not believe those fees were appropriately instituted, nor were they demonstrated as being necessary based upon a study completed for the county itself. So we did not agree to pay those fees.
Okay. Is it the company's position that the impact fees are the only reason why Big Sandy and Kiowa did not countersign the fire forms?
Based on the information at hand, it appears, if not the only, a major factor when the direct comment was that they would sign when they're paid fees.
I guess I'm confused by that response. Are there reasons other than the impact fees that was articulated to the company or that the company is aware of as to why the fire divisions didn't countersign these forms?
I think we could certainly look at Big Sandy and Kiowa's comments to the county if we'd like, so that I'm not basing my opinion on my recollection.
Yeah, absolutely. But I guess as you're sitting there right now, is it the company's position that the company has addressed every concern expressed by these local fire divisions?
We believe that we have provided the wildfire mitigation plan, both approved by this Public Utilities Commission. We also provided a jurisdiction or Elbert County specific plan. We believe it addressed all of the requirements and concerns. If there is still contention about impact to resources and things, that is probably part of additional conversation to be had with fire districts.
Yeah, absolutely. And we can take this exhibit down. But Ms. Chester, you insinuated about a public comment. So I'd like to bring up that public comment. It's not a part of the record. It's exhibit 210. If we could bring that up, if that's possible. Okay. Ms. Chester, have you seen this before? And we can feel free to ask to scroll through it, just so that you know what it is.
I'm not sure. Appears to be submitted to the PUC. I don't see a date on it. But...
Yeah, can we scroll down a little bit, please? Yeah, as you suggested, and I'm wondering if you were referring to a different public comment, but hopefully my line of questioning kind of clears this up. If we scroll all the way to the bottom, this is a public comment that was filed directly with the PUC. It's part of the PUC's files. And it is a document dated January 27th, 2026. So roughly a month ago. It is signed by Big Sandy Fire Protection District, as well as Kiowa Fire Protection District fire chiefs for both. And I'm not even going to take a stab at pronouncing their last names, but any reason to disagree with me that this document was sent in to the PUC?
If it has the docket information up at the top and has been filed with the PUC, no, I don't have any reason to believe that's not the case.
I want to ask you questions about this, but at this time, I would ask that the commissioners and the PUC take administrative notice under its regulations of this letter, since it is a part of the PUC's files. I would like to have it moved into the record based on that administrative notice. And I'm happy to provide further clarity or a specific pin site to the PUC's regulations if needed.
Any objection, Ms. Caliendo?
No objection, but just noting that this does not appear to have the stamp from the PUC's e-filings, but if there's a version of that may be more appropriate.
Can we scroll down, please? I think that
withdrawn.
It does look like it has a stamp. So admitted.
All right. Thank you.
I guess just wanted to check in with you, Mr. Bell.
Yes.
You're about an hour in. Should we take a break now, or how much more time you think you might need?
I have 3 pages left on my outline. So however talkative Ms. Chester feels, I feel like I could probably wrap this up in about 15-20 minutes.
All right, let's take a brief break till 10:50. We'll come back at 10:50 and we'll finish up with your cross of Ms. Chester, 10:50.
Thank you.
Ms. Chester, are you there? And just for the benefit of the parties, I just want to let you guys know we're going to break a little early today, around four-ish, for a PUC event. So early break today. Back to you, Mr. Bell.
Ms. Chester, we're back from taking our break, but I'd like to ask you about these public comments submitted by Big Sandy and Kiowa. So if we could scroll down a little bit. Okay. At this point, Big Sandy indicates that it had requested XL to incorporate key safety features into the project, such as video observation cameras, remote weather stations, or other early detection devices to enhance early and rapid wildfire response capabilities. It indicated that these measures are essential given the elevated fire risks in the affected region, which include dry vegetation, rapid weather changes, and recurring high wind events. It indicates that XL failed to commit to installation of any of the safety enhancements within the affected areas of Elbert County. Did I read that paragraph or paraphrase that paragraph accurately?
I believe so, yes.
Okay, can we go to the next page, please? And specifically, both fire districts outline numerous safety critical items that remain unanswered. And again, this letter is from about a month ago. It says these missing critical items include whether the segment of power line passing through Elbert County is included in XL's wildfire mitigation program and classified as a wildfire zone. The next bullet indicates whether the power line design includes reclosers, relays, or other protective devices, and including whether such devices will remotely be monitored or controlled. And then the third and final one is detailed construction documents for the project, including the number, height, and configuration of utility poles or towers within the power line corridor through Elbert County. Isn't that right?
If you're asking if that's what it says, yes, that's what it says. We provide that information, however, so I would disagree that that's still outstanding.
Okay. So despite the company's position that it has addressed Big Sandy and Kiowa's concerns, during both the pre-application and application process, this public comment indicates that the local fire divisions disagree with the company's stance in that it has provided all the necessary information. Isn't that right?
It's unclear to me if information provided to Elbert County that addressed these comments that came through the permitting process were provided to the fire districts. This letter doesn't address that.
Shouldn't that information though have been exchanged by the company to the fire divisions during the conferral with the fire divisions?
The communication path during the land use permitting process was typical that the jurisdiction, in this case Elbert County, send out referral response questions or referral response materials. Those agencies respond to the county provides those to us as the applicant, we respond back to the county. So that's how that typically works. We did have members of the company meet with fire districts staff at various points. And so some of those communications have occurred directly, but as it relates to the land use permit applications, those materials and communications typically kind of flow through the county so that it's part of the record associated with the land use permit application.
Okay, but as we're sitting here today, it appears that Big Sandy and Kiowa are still missing information from the company, right?
It appears they're looking for information which may exist and was provided to Elbert County as part of the comments that they provided.
I'd like to shift gears a little bit, and I know we're kind of short on time, but I do think this might be a really productive area of questioning, Ms. Chester. So as you sit here today, are there other routes other than the preferred route? And I'm sorry, we can take this exhibit down. I don't mean to distract you. let me start over. Are there other routes other than the preferred route that XL identified that XL has not eliminated as potential alternatives for the portion of segment 5 running through Elbert County?
I'll answer that in form of restating just to make sure I understood. And if I misunderstood your question, please let me know. We provided applications for a proposed route through Elbert County as described in the routing study attached to the applications. We evaluated a number of alternatives and selected a route that we put forth in the applications.
Okay, so let me rephrase it. Are there other routes that remain as viable alternatives for the portion of segment 5 running through Elbert County, or have all alternatives identified by the company been eliminated?
Generally, we have identified a single preferred route among the alternatives evaluated. So we are not at this time considering other alternatives.
Okay, so the answer to that is no, right?
Objection. Mischaracterizes Ms. Chester's testimony.
Well, let me rephrase it, Commissioner, hopefully to avoid the objection. She just said that she has not identified any alternatives at this time other than the preferred route that was selected. My question is really, are there any alternatives that remain viable or that have not been eliminated by the company other than the preferred route? She said there are no, they have not identified other alternatives. The answer to that question boiled down is no. Is that fair, Ms. Chester?
No,
Does that
I renew my
mischaracterize?
objection. That mischaracterizes her testimony.
Overruled. The witness can recharacterize any way she wants.
Yeah, as I stated, we evaluated a number of alternatives in our routing study. We selected a route that we put forth in the applications to Elbert County.
Okay. I guess let's just pull up some documents and hopefully that answers my questions. In your rebuttal testimony, you provided a figure called JLC-R-1, which was titled Segment 5 Routing History. Do you recall embedding an actual image of that in your rebuttal testimony?
I do. I don't know if we're pulling it up, but I'm familiar, yes.
We are. Can we pull up Hearing Exhibit 105, please? Wow, it's fast. Can we go to page 15, please? Okay. So, Ms. Chester, and a lot of this is going to be due to my naivety, but I'm hopefully going to ask you questions that kind of provide me a little more context. So this figure is called Segment 5 Routing History, and it provides 6 different, I'll say, pictures that, from what I can tell, reflects the evolution of the original 20-mile study area to the routes that XL identified going through Elbert County. Is that accurate so far?
Yes, I would say that's accurate.
So the figure on the far right, which is titled Preferred Route Links, and it's in orange. Do you see that?
Yes.
Was this the most recent depiction of the routes that XL identified and has eliminated? Is this the most recent one?
Not necessarily. So the column or the graphic on the right that you're just referring to, that was at the time we selected the preferred route. So previously noted by yourself and by me that was selected in December of 2022. At that point in time, as you referenced the evolution of the maps here, we had moved through adjustments to study areas, identified different alternatives. We had eliminated some of them for further consideration at various points. Those are shown in red. At the time on the right-hand side here that we selected the preferred route, we had eliminated a number of links from further consideration as shown in red. We were then selecting from among those that were not eliminated from consideration and selected the preferred in green.
Okay, okay, that's helpful, and I really do appreciate that, Ms. Chester. So this was the same figure that Excel had provided in its pre-application packet, or the PowerPoint presentation that the company presented to Elbert County in July of 2023. Is that right?
Yes.
Okay. Can we pull up hearing exhibit 206 CP1, please? And can we, before I get into that, does this appear to be, I believe we used a different version of your, the attachment to your testimony, but does this appear to be the pre-application packet that Excel had submitted?
It appears to be the first page of the letter, yes.
Okay. Can we go to page 35, please, of the PDF? Thank you. Can we scroll down a little bit so Ms. Chester can see? Okay. Now, does this appear to be the far right picture that we had looked at in that evolution figure in your rebuttal testimony?
If not exactly the same, it's similar, yes.
Okay, similar. And was this the same figure that was presented to the Board of County Commissioners during the hearing on June 24th, 2025?
I'd have to look at the what you're referencing there to be sure.
So fair. Yeah, I apologize. Fair enough. Can we bring up hearing exhibit 105, attachment JLC 20, please? And can we scroll down, please? Next one, next one. There we go. So this is the same evolution of the routes, right? That was submitted to that was presented to the Board of County Commissioners?
Yes.
All right, so actually I think this same PowerPoint presentation actually does a really good job of showing a better view. Can we go to page 6, please? Perfect. Does this appear to be the same figure that we've gone over, or the same picture that we've gone over?
Yes.
Okay. So this was the same picture that was submitted in the pre-application packet. And this is great because it actually shows a really zoomed in view, and it helps my eyes, but and it also has a legend. So this is great. So the green, that is the preferred transmission link that the company selected towards the end of 2022. Is that right?
Yeah, link was a term for kind of little segments of line. So that green line is actually a series of links that are connected. But yes, that represents the preferred route that was selected in December of 2022.
Thank you for that clarification. I do appreciate it. So the green line refers a combination of links that make up the preferred transmission route, right?
Yes.
And everything in red were routes, or I'll just say routes, but were routes that the company had identified, analyzed, and then ultimately eliminated, right?
From further consideration at the time. Yeah, that's right.
And then everything that's in orange or yellow, we'll just say the other color, that reflects alternative transmission links, right?
Those were still being evaluated as part of the routing study at the time the preferred was selected. Yes.
Okay. And then the area to the east, to the right, that has been referred to as the Eastern Review area. Is that correct?
Some portion of that is the Eastern Review area. Some portion of it is just part of a various, a focus area during the routing study, but generally fair to, I would say, refer to it as the Eastern Review area.
Can we zoom in a little bit, please, to the map, just the northern part, just where it says Elbert? Thanks. So, Ms. Chester, now bear with me. In the gray shading, where it begins with EL for Elbert, you see where I'm referring to in that portion of the map?
I do, yes.
I don't see any proposed routes or any routes identifying a route through that area. Is that right?
Yeah, I believe that's right, yes.
So am I to understand correctly by there being no red lines through that area, that means that the company did not evaluate a potential route going through that area and then ultimately eliminated it?
We studied that area and did not identify routes in that location that met the criteria to be identified as a route. That's correct.
Okay. So if we go to the siting and routing study, can we pull up hearing exhibit 102, attachment JLC 1? And this is a rather large document and my computer runs pretty slow when I try to operate this. So just so everybody's aware, it does take a little bit of time to peruse through the document. Ms. Chester, is this the routing and siting study that the company submitted with its application?
Yes.
And can we go to page 59, please? All right. So this shows another view of the kind of routes that the company analyzed and ultimately submitted this siting and routing study to the county so that the county could be aware of the particular routes that the company had identified. Now, can we zoom in a little bit in between? Oh gosh, how do I describe this? It says 5160. We could just zoom into that really large blank space in between. We go up. Right, perfect. Miss Chester, do you see the area where it says County Road 150?
I do, yes.
And it looks like it's in between links 5160 and 599, although my eyes may deceive me. Do you see where I'm referring to?
Yes, I think so.
So you see that rather large area right there where there's no, I'm sorry, go ahead.
I do see it, yes.
Okay. So again, by there being no red line through this area, it reflects that the company didn't identify a particular link going through that area as a potential option, and then the company therefore eliminated it for whatever reason. Is that fair to say?
We studied the area and did not identify a link, correct?
In general, the focus area was made up of probably like a western part, an eastern part, and then the part called the Eastern Review area. Is that accurate so far?
Trying to think through the pictures because there's kind of six there. I would say for now, I would generally agree there's a western area, a central area, and an eastern area.
Does it sound about right that the company identified and examined more than 40 potential links in the western area of the focus area?
We can certainly count those on the page if that's what you're talking about. Here is referencing is the western area. It was a large number of links that are identified here.
Does it sound about right that 4 links were identified and analyzed by the company in the eastern part of the focus area? Not the eastern review area, but the eastern part of the review of the focus area?
I guess I'm going to need a definition now on what we're calling the regions to make sure we're clear. If you want to refer to link numbers, that might help me understand how you're.
Yeah, and I guess this might be a little bit deceiving, so we can pull this down, but I'm just trying to gauge your memory in terms of the links that the company had identified and whether it matches up with your recollection. But it sounds about right that in your words, a lot of links were analyzed in the western part of the focus area. Now, if we look at the eastern review area, does it sound about right that 8 links were identified and evaluated by the company in the eastern review area?
I haven't counted. Again, we can certainly count together, but otherwise I would say there's a number around that.
When Excel originally mapped out the 20-mile study area, and that was reflected by the far left column of the evolution of the route. At that time, when Excel identified that 20-mile study area, it corresponded with the United States Air Force Academy. Isn't that right?
Corresponded with, meaning?
That's a great point. I use that word, but Excel had communicated with the Air Force Academy. Is that right?
At the time of the 20-mile wide study area, no, not necessarily. Feedback from the Air Force Academy came later when we were out talking to jurisdictions about the project and agencies.
I see. And I appreciate it. And based on those communications with the Air Force Academy and the comments that you received, they requested that the route go further east, right, to avoid potential issues?
The Air Force Academy and others that have designated airspace and training areas, yes. So the Air Force Academy was one of those that certainly had designated training areas, and we were asked to avoid those and to move the route further east.
And the company complied, right?
We evaluated if we could do that and ultimately determined that yes, we could, and we did identify those links further to the east.
You were present during the El Paso hearing, right?
In front of the El Paso Board of County Commissioners or the PUC hearing?
A great follow-up question, so I do appreciate that. You were present at the El Paso PUC hearing a couple weeks ago, right?
I was, yes.
And in that case, Excel was amenable to pushing that route running through El Paso County further east to avoid heavy populated areas. Is that right?
I don't believe that was stated by me in that PUC hearing, no.
Sure, it wasn't stated by you, but the evidence reflected that the company ultimately pushed the route that it had selected further east to avoid populated areas at the request of El Paso County, right?
Objection, that mischaracterizes Ms. Chester's testimony, and counsel has not provided any evidence of such.
Can you rephrase the question, Mr. Bell?
I can move on, Commissioner. Isn't it possible, Ms. Chester, that Excel and the county could work together to find a route further east that worked for both the company and the county?
I don't think I could speculate on whether that's possible or not. We evaluated a number of options, coordinated with the Elbert County community, the county itself, to evaluate those. And the suggestion that there is something different, better, further east is not really founded in fact, based on the routing study and analysis that we did.
Okay. Ms. Chester, I appreciate your time today. Those are the questions that I have for you. Thank you so much.
Thank you.
Thank you, Mr. Bell. Commissioner Plan, I don't think council has questions for Ms. Chester.
Thank you. And good morning, Ms. Chester.
Hi there.
So if I have a timeline correct, and I know you just went through this with Mr. Bell as well.
Sure.
You initially notified the county of the project in the summer of 2021. And it was the pre-application was submitted in 23. You had selected the route by 2022. So the pre-application was submitted in July of 2023. And the ultimate rejection of the permit was in July 2025. What sort of happened in that intervening time? That is that a normal time process, 4 years, for something like this to take, or is this unusual?
No, it's not. It's not normal. I would say. So certainly, segment 5 as a whole, we invested a lot of time in working with folks on the routing of the segment 5 route, especially when compared to others, other segments. Right, we initiated work on pathway as a whole in 2021, as noted when we filed the CPCN. And worked with jurisdictions and communities to identify route locations for other segments, have that permitted, and those are under construction and in some cases in service today. We engaged and initiated work with segment 5 jurisdictions and communities at the same time. So the segment 5 took us about twice as long, maybe as compared to others. We spent that much more time working on routing, as shown in that graphic that was on screen a little bit ago, the segment 5 routing history, the evolution of where were we looking? Where did we start? Where did we add additional area? What did we consider based on public feedback and agency feedback? And we spent significantly more time in identifying segment 5 route.
Okay, thanks. And as I understand it, the impact fees aren't universal, but have you had these in other jurisdictions that you operate in?
We do see in some jurisdictions impact fees assessed on projects due upon approval of the application and before it started construction. We also work in many jurisdictions in Colorado that don't have impact fees. Probably a larger number that don't have impact fees that we work with. They assess other types of fees. Maybe that's application review fees, or we understand if we're working with them on concerns about road impacts, that we repair the roads and so on, so that that's not a financial burden for them. We also work with a number of fire districts that engage with our projects, rebuilds, and so on across the state as well. So I would say there are some, and there are many that don't have those types of fees, but have other ways of working with the company or have other ways to address impacts and collect fees.
And in your experience, do the impact fees generally come, as in this case, from a sort of a percentage calculation versus, an itemization of, specific impacts and projected costs? Which way is sort of a normal way for that to happen?
Yeah, good question. What is normal? So
yeah, maybe normal is the wrong word. I don't know.
Yeah, I think that it is common amongst jurisdictions that have impact fees for it to be a percent in certain instances. In other instances, we do see more flat fees, or it's just this type of application or this type of project has a flat fee. I think the difference being just in terms of maybe which jurisdictions have implemented fees and why they've chosen to implement those fees, and the types of development that they're seeing that they feel that those apply to. It tends to be more maybe Eastern Colorado, for example, and not Metro or Western Colorado. typically.
So it's meant to be kind of more of a general assessment as opposed to a specific assessment of
Uh-oh. Did Commissioner Plant
a
freeze for
related
everyone or
cost.
just
It's
me?
not
Just you.
Oh, I'm sorry. Did I disappear? So I'll try and say it again. So in general, the impact fees are sort of a more of a general assessment as opposed to a specific itemization of, identified costs. It's meant to cover a variety of things. Is that correct?
Oh, sorry if it suggested such. No, I mean, I think that their percentage calculations related to maybe the construction in that particular jurisdiction, which is intended to account for what they think the impact might be. So
And I'm sorry, those are impacts on county. So like, for example, when you say construction, you're talking about maybe roads, county roads, or they're specific to the county impacts. Is that generally what it's?
Yeah, that's generally correct. So it could be that there's a road impact fee or an impact fee that's intended to cover road impacts among other types of things. Sometimes we see fees for processing applications. We pay fees for review of our applications. So in the case of Elbert County, we paid the cost of the third-party reviewer, those fees associated with that. So it can be any number of things depending on what that particular jurisdiction feels would be necessary to cover the cost of.
Those are generally though application fees though, not impact fees, right? Is that correct?
Yeah, I think in the world of what's normal or typical in Colorado, we typically see application fees and things as being the regular and smaller numbers of jurisdictions actually having impact fees specifically.
And as the permitting agency, does the county generally act as the collector of fees for impacted districts? So for example, in this case, you've got 3 different fire protection districts. Their boundaries kind of overlap the county in various different ways, but they're a different sort of entity than a county government entity. But since the county is the permitting agency, do they generally collect on behalf of those districts, or is it really up to those districts to identify, any costs and assess fees in their own way?
Yeah, in my experience in Colorado, we generally see fees assessed by that particular jurisdiction if it's a county, and how they disperse those funds among groups within the county or other things like fire districts. We don't necessarily have visibility on. We pay the fee to the county.
But that generally goes through the county because your relationship is with the county, and so you pay the county, and the county then pays the districts in general. Is that
if they are paying the districts, again, it's hard for me to know what they do with the money, but I can say in my experience in Colorado, not only permitting for Pathway, but all the other numbers of jurisdictions that we work with, I can't think of a time that we've paid like a fire district impact fee directly to them. So I think that would be unique, but I can't speak for, I guess, every jurisdiction in Colorado, but for Pathway, we haven't paid a fee to other volunteer fire districts or something. For example, we paid impact fees that were assessed and in code for jurisdictions that had them.
Gotcha. But you do work with those fire districts in other areas to address various concerns as was outlined here.
Yeah, absolutely very typical for us and our construction contractor to engage with fire districts. I would say the timing is more typical for that to be, around the time of construction in advance of the start, but around the time to talk about, here's where we'll be, here's what we'll be doing, what questions do you have, here's our emergency response plan. Our construction contractors always have emergency plans in place. That's a requirement, and they put that out there for their use. They're interested in the safety of their crews and the community as well. You know, if someone's hurt, they want to know that they can get them to the proper emergency responders. So we have those in place, and we work with the fire districts and other emergency responders as we approach construction. So it's more typical for us to do that then. I don't think that in the case of Pathway that we had any other requirements like for fire district forms to be signed or something like that as part of the permitting process.
I understand, and that was an established part of the SUR process in Elbert County. Is that correct?
It was something we were. Oops, sorry.
I'm sorry. That signed fire protection and safety agreement. That was a established part of the SUR process in Elbert County.
That's something we were asked to provide as part of the SUR process, those forms, yes.
Okay, I understand. Thank you. I don't have any further questions.
Thank you, Commissioner Plant. Commissioner Gellman.
Hi, Ms. Chester. Good morning.
Good morning.
Just a couple questions. I wanted to follow up on Commissioner Plant's, make sure I follow all the timelines here.
Sure.
So primarily the additional routes were studied in 2022. Is that a appropriate understanding?
Additional routes like those that were in the Eastern Review area were studied in 2022. That's right.
Okay. And then my understanding is you selected the preferred route in December 2022?
Yes, that's correct.
Okay, got it. And then you submitted a pre-application in 2023. I think it's the middle of the year.
Yes, yes, July of 2023.
Okay. And then the actual application in November of 24.
Yes, that's correct.
And as I think was gone over, that was about a year after the company's initial expectation. Just understanding certainly the company's position here is that time is of the essence. I was just curious, granted, I see in the record a lot of comments you got on the pre-application, and so help me understand what went on and caused the delay from your intended application in the end of 23 to instead the end of 24.
Yes, happy to talk about that. So as discussed earlier with Mr. Bell and the pre-app comments that we received back and the requirements for the application, the level of detail and what they, Elbert County was looking for in terms of each pole and understanding the height and the landowner and temporary construction areas and access and a long list of very detailed items in order to be responsive to those requests to provide that level of detail, which is additional and different than most other jurisdictions that we've permitted in Pathway. In order to collect that information and be able to provide it to Elbert County, it took us the additional time to work with landowners to gain access where we could to property so that we could conduct detailed studies. So for example, a geotechnical analysis requires us to actually access a property and drill on that property. So we spent the year from kind of the original plan timeframe to when we ultimately did submit, working to gain as much access as we could to property, to do studies, to inform a detailed engineering package. That is ultimately what we submitted in our applications to Elbert County to show pole locations and our construction areas like pool sites, potential construction yards, access routes, and all of that. That took a lot of time, as you can imagine, working with landowners to get that access, and then for our construction team to make a lot of field visits to review and make decisions about that, along with our engineering team working to design the line. And then in some cases, we were micro-siting poles based on landowner requests. Could you shift it over here? Could you make it further over that way? So all of that work was happening primarily in 2024 as we continued to develop the application materials.
Okay, understood. Thanks. And let's rewind to 2022 really quickly when the company primarily was or expanded the study area to look at other route options. To my understanding, the company had significant concerns, especially around I can get there. Conservation easements
Yes.
and feasibility in the eastern area specifically. And I was curious, what was the feedback mechanism, if any, as you were studying that to share what you were finding with the county or with others involved?
Yeah, as part of not the entire routing process, but in 2022, we held additional community meetings. So the Eastern Review area was not in our prior study area, for example, and we received feedback that we should look further east, that there seemed to be potentially a better route out that way. So we created the Eastern Review area, evaluated additional data, and then met with the community. Not only the community, kind of in the prior study area or focus areas it was called at the time, we met with those folks and did open houses, had large format maps on the table, lots of information boards, SMEs, so that we could collect feedback. Where should we be? What are you concerned about? We went through an exercise in those meetings, asking folks, to tell us where they think it should be. We asked them to put dots on maps, for example, help us understand of the lines on the map, which ones do you like? We got a lot of pushback on that particular exercise, and folks saying they didn't want to put dots on a map that impacted their neighbor. So it was a little challenging sometimes to get very specific feedback about where this route further east was. So we looked at additional data, put lines on a map based on some of what we heard. So for example, we heard a suggestion that maybe along County Road 125 would be a good place to go. Nobody lives over there. So that's one of the routes that you see. Or further east, again, nobody lives over there, so that would be a good place for it to be. We went out and met with the communities, including those in the Eastern Review area that previously hadn't been engaged in the project. They weren't in a study area. They hadn't had an opportunity over those years to provide comments. So we went out and met with them and took their feedback into account in the evaluation. When we selected the preferred route, we communicated that out through all of our typical channels, which includes website. We have a number of subscribers to a newsletter, and posted all of that information out that way and notified the public of the selection of the preferred route at that time.
Okay. You indicated, I think it was in your rebuttal, what you called numerous changes to the final proposed route. I was curious if you could be more specific for me in terms of like how was the route modified specifically based on these interactions or feedback or the different studies that the company conducted.
Yeah, and I'm a hand talker and I'm a visual person, so I don't know if it's helpful at all to bring up that routing study figure, but if not, let's assume everyone has it memorized. As we moved through different things, on the far left, for example, we see a fewer number of links in a different area. And we went out and held a series of public meetings and folks said, we think you should explore different things. You should eliminate this, don't look over here because there's a thing, maybe look over there, co-locating more, with existing transmission. And we would add lines on a map to further evaluate those. And then we would take those lines on the map back out to the next round of public meetings, which kind of each of those maps represent a series of public meetings where we were out talking about the latest changes or additions. We would collect feedback at public meetings. As I mentioned, we had large sheet maps on tables and folks would say, I just started the foundation of my house here yesterday. So we wouldn't have seen that 5 days prior if we were out in the field. So we would take notes on those sorts of things and look to adjust lines. We would have landowners come in and say, that's really kind of the front of my my ranch, could you put it, over in this location instead towards the back? And so we would make those adjustments as well. So any number of things. Sometimes we were switching sides of the road. Sometimes we were adjusting lines on individual properties at their suggestion. And in some cases, we were making decisions that we needed to eliminate something because we've learned, new information that made that not a very good option to consider.
Okay. To my understanding, the county points in some of their testimony to a cost control mechanism for the project put in place by the commission that it sounds like wasn't maybe disclosed to them until later, with a concern that the companies, I guess if I'm paraphrasing what I read, like the company's concerns about cost and cost containment were major drivers in the decision. So I was just curious if you could help me kind of understand and paint the picture in your process in assessing feasibility. What happens first, then next to like try to hone in on what is feasible or possible and where does cost fall in the stacking of conservation easements and feasibility to build on all these multiple factors.
Yeah, certainly. So as we work through the routing process, and it's an attachment to one of my attachments, which is the routing study. There are a number of detailed tables in the routing study that explain kind of what were the criteria we even looked for to put lines on the map in the first place. And then as we work through the study, how did we change those lines and maybe why? And then maybe most importantly, there is the comparative matrix table. It's a number of pages, lots of cells in a spreadsheet where we took each of the links being evaluated and collected just a massive amount of data across dozens of things to look at how long is it, how many parcels does it cross, do we have sensitive species habitat, are there wetlands, what bugs and bunnies are important here, how many homes are within certain distances of the line that we were using to evaluate. Any number of those could impact cost, but what you won't see in that table is a line item for cost. We didn't cost it out and say anything above this is off the table, anything below this is really great in terms of the PIM, but line length impacts cost. Line length also causes additional impact. If a line is 20 miles longer, that's 20 miles more property, that's 20 miles more potential species habitat. So what we did in our analysis is we collected all of that data on all the lines on the map, and we sat down and looked at it and said, if we have three kind of options in an area, generally running north-south, of those three, what do we know about them? This one crosses a lot more wetlands. This one goes by more homes. This one has some wetlands and some homes. And so maybe, we balance all of that and pick one of those. And then we go to the next one and kind of the next area and compare those. So it's really a comparative analysis, not a this one costs X dollars, booted off the map, so to speak, because we were looking at trying to balance everything. And that includes costs. We obviously want to be prudent with the dollars spent for our ratepayers and make smart decisions. If there was an option that was maybe an additional length, but had less impact, that would be something we would consider in the analysis and did consider to say, maybe we could go a little further this direction, kind of out of the way, but it avoids homes, it avoids wetlands, it avoids things. And that balance was worth it for what would probably be additional cost. I think as we think about the eastern routes, for example, as have been discussed today, part of the challenge with those is that it added not only additional length, additional costs, but it wasn't giving us less impact. It wasn't balancing the factors. It was making it more this way, but it wasn't having less impact on resources and other things. So it didn't make sense in the way that we have to try and balance those things, cost included, to go additionally east to not get a benefit that justified additional cost.
Okay. Thanks. Moving on to a different topic. So in your rebuttal, you had refuted the county's claims regarding their opposition to the company only submitting one preferred route in the permit by including a request shown by Mr. Deaton Ryder. I think I got the name right. That request had asked for more detailed information, like about where towers will be located, where concrete batch plant will be, lay down yard. Some of that we see replicated, like requests for specifics around location and aspects of the towers, and the letter from the 2 fire districts that was brought up before, the public comment, I guess I should say, that was brought up before. Help me to clarify and understand, is it the company's position that you've provided all of the information that has been requested by the county, or is there outstanding information?
In terms of things like pole locations, there's no concrete batch plant proposed in Elbert County, so we can cross that one off the list, nothing to provide there. We provided pole locations, detailed information about access and temporary construction areas. So that comment, you know, that was provided in the completeness review is I noted earlier, we felt was a little unfair because we weren't looking at the responses to comments, because we did provide that information in our application materials, and in our response to Elbert County, we indicated where that information was provided. So we provided a great deal of information regarding the location of the facilities, other easements even, and that's what allowed some folks like Core Electric to respond in their referral review in great detail, because they were able to tell where the lines and poles were going relative to their facilities. So I believe that we have provided everything asked for, and then some, the exception being, as we've discussed, fire district forms signed by fire districts. We signed the forms and are willing to sign the forms, but you know, we can't force those districts to provide them. So we acknowledge those were not provided by the fire districts.
Okay. And then going back and with the fire districts, has the company made outreach specifically to the fire districts to try to start or continue that coordination?
Yeah, so we had one of the fire districts sign the forms. Tri-County Fire signed their form. The other two, in the interim since the permit denial and today, we haven't necessarily had project interaction with those fire districts, as we've been working through kind of this litigated process, other than reaching out to see if they would like to get access to the Pano AI camera system that we have. And extend that offer. We made that offer in June during the hearings, that we would work with OEMs and fire districts to get them access regardless of any permitting outcome. And so we have reached out to see if they would like to get access to the camera system.
Okay. And sorry, I'm just trying to keep it all clear in my mind, make sure I'm very clear. Do the fire districts provide comments to the application that you made with the county?
They did. They provided what would typically be referral comments. So they provided comments to the county. So the county sent out requests for their comments on our application. And the fire districts, in certain instances, provided comment back to them, which were then provided to us as the applicant. And then we provided our responses to those to the county.
Okay. And we're still seeing in this public comment filed fairly recently by 2 of the fire districts, at least those 2 fire districts, asserting that they've made repeated requests for certain information from the company that they have not received with regard to construction documents, some safety features, equipment specifications, and wildfire mitigation plans. So I just want to understand from your perspective, is it your position that this is information that has already been provided? Or do you believe there is information that is outstanding here?
I believe the information that they're seeking or mentioning in that particular comment has been provided by the company through the Elbert County permitting process. But certainly open to engaging with fire districts directly to make sure they have that information directly from us if they did not get it through the permitting process.
Okay. And the letter doesn't indicate to whom the repeated requests were made. To your understanding, were those requests made to the company?
I actually am not sure who those repeated requests were made to, unfortunately. So I don't know. I don't know if they were made through the county or if they felt that the referral comments were requests and then it wasn't getting transferred. But part of what would be available to discuss in our kind of commitments document that was mentioned earlier is as we have for other jurisdictions. Consistently, we certainly would commit to working with the fire districts to provide information that they need and work with them on their concerns as they have them.
Okay. Can you help me understand which of the fire districts within Elbert County have identified to the company that they have a separate or expect a separate impact fee in addition to what the county more generally has identified?
Yeah, I think the primary one during the permitting process was Big Sandy. Big Sandy initially responded that they would sign the form after approval of the application and then subsequently provided different information that they would sign the form after payment of the fees. We asked for information on the fees to help us understand where those were coming from, how they were instituted, because that wasn't part of their original feedback to us regarding the forms. So that was one instance. Kiowa fire districts maybe asked was a little less clear in terms of fees or what they thought they might need financially for impacts they were perceiving. So I think the two situations are a little different. I don't think we saw any requests from Tri-County for any fees. They signed the form.
Okay. And can you just help me understand to the best that you know how and when the separate fire impact fee, at least from Big Sandy, was communicated to the company? I'm trying to place that in the timeline of events where.
Yeah, one of the attachments to my testimony, and I'm trying to look at the list to see if it's helpful to pull it up, would have that detail. I believe it was April, May, and we can confirm that with my attachment where we saw the communication that said, we'll sign your form if you pay the fee. As part of the communication about the fees, they provided some documentation of some work with the county that happened subsequent to that, like right around that time. So like it seemed like they were being implemented maybe real time as we were working through our application at that point in time. So prior to that, we hadn't had any of that type of communication.
Okay, and when you say April or May, you're talking about April or May of 2025?
Yes.
Okay, great. Yeah, if you can figure out, it doesn't have to be right now, but what document that's on, that would be very helpful for me. Sorry, there's a lot and I'm trying to make sure I've got them all clear. Just one last question for me is with regard to you had talked about there's kind of this county impact fee issue. Some counties have impact fees, some do not. But I think you've also talked about there are certain commitments or expectations that the company expects to abide by in terms of their use of, say, roads and fixing any roads. So can you help me understand you know, the county has a list of conditions which the company is not agreeing to. Then there's the impact fee situation. Then I wanted to talk about perhaps a third flavor here in terms of what does the company see as standard obligations or commitments that don't live in either of those, but that are just your assumed operations to ensure that you've minimized any impact.
Yeah, absolutely. I don't know if it's easiest or appropriate to bring up the document that we prepared that lists all of those things. I know it's not entered into the record, so just want to make sure I'm following process. I don't know how to do that here. Otherwise, I can just generally talk to it.
Same. I don't know, Chairman.
Yeah, Commissioner Gilman, we have
I
that
was thinking
document.
maybe on redirect, Ms. Caliendo, and then that would give the county witnesses to the extent they want, and I'll commit to asking them if they have any comments or concerns on it. So I think that might be the best way to do it. Would that work for you, Ms. Caliendo, or you have an alternative suggestion?
That's fine by us. We can also bring it up now if Commissioner Gilman would like to look at it and talk through it. Your preference.
Commissioner Gilman?
I'm okay, you know, if you guys want to go over it on redirect. I'm just trying to understand of the many flavors these impacts could go and what the company commits to as just like standard course, just so I better understand that.
Yeah, would it be helpful if I talk maybe about the 3 buckets I think you described?
Yeah, I think that's fine.
Okay, so you know, I think in terms of the things, and maybe I'm working in reverse from the way that you listed them, the standards. If we cause damage to a road during construction, you know, then we will repair that damage to the road. At the end of construction, they'll be returned to the pre-construction condition. We take baseline surveys so we understand what that is and have good documentation. So that is standard. That is standard operating practice for us as part of construction anywhere, regardless of whether there's a road use agreement or a road impact fee or not. That is work that we do and our construction contractor is expected to take on. So that's kind of, you know, in the standards. Other standards are things like operating hours, just good best management practices about restoration. We have obligations to obtain state stormwater permits and erosion control permits, and we adhere to the things that are required in there about best management practices and erosion control. That happens regardless of whether, you know, there's a condition on a permit or a county says it, because that's a state level permit. So, you know, we follow all local, state, and federal guidelines in that way. We regularly and always work with CPW and Fish and Wildlife regarding recommended, you know, practices during construction. So those are definites, and we've done that and even coordinated and discussed Elbert County, among others, with them as part of the Pathway Project. So those are the standards that would be included. Elbert County and their staff report did provide a list of recommended conditions should another entity approve the application, which is a pretty unusual way to put that forward. Typically we see here's potential conditions of approval that a county could implement upon approval of the application. So that staff report wording was unusual, but regardless, we went through those as part of our BOCC hearing in terms of what we would be able to agree to, some suggested revisions for clarity and so on. Those will be part of the document that perhaps we can go over on redirect. More specifically, those included things like providing emergency response plans to the fire districts, conducting training with the fire districts. We are agreeing to do those things regardless. And then, yeah, the impact fees is a whole nother can of worms, bucket of worms.
Yeah, sure. Thank you for at least going over it at a high level, just so I have some understanding. I know there's a lot of different commitment impact the issues flying around. So I want to make sure I understand where the company is on that. Chairman, those are my only questions.
Thank you, Commissioner Gilman. Just starting out on state assessed taxes, do you know what they are for Elbert County and say the first year of project operations? I know they decline with depreciation, but can you let me know what they might be?
Yeah, we had provided the numbers in our BOCC presentation in June for the prior year. And we can double check my memory, but I believe we were paying over I know we were paying over $2 million the prior year in state assessed taxes to Elbert County for our facilities there.
No, not what's the I'm not asking you what you pay Elbert County in terms of existing equipment. I'm asking you how much does the Colorado Power Pathway add? What's the incremental amount to property taxes?
I see. Yes. The number would be dependent on final location and any certain districts and things that it crosses through. But I believe the number would be similar to what we saw with El Paso County, maybe a couple $100,000 additional.
Okay. And on page 46 of your answer testimony, you state that the company would have been required to pay $2.5 million in impact fees to the county if the company's application had been approved. Can you just help me make sure I understand the basis for that? Is it just total construction costs multiplied by a fixed percentage, whatever? I think it's 2%.
Yeah, Elbert County's code defines that it's not really called an impact fee. I believe it's called a construction fee in their code. That is a percent of the anticipated construction cost. So we arrived at that number just based on estimates on the preferred route length and typical construction costs for pathway to come up with that number as an estimated number.
And I'll just ask you the same question I asked Mr. Lunar. If the commission finds that there are adverse impacts associated with the line that are, say, above the $200,000 a year, given the company's rejection of the $2.5 million in the county approved process, any advice about the basis for determining an appropriate fee? Any guidance, thoughts?
Yeah, similarly big question as we've seen before. I think about how do we address that? What is the intent of the impact fee? And Elbert County Code specifically says that construction fee, or whatever it's called, is due upon approval of the application. And so that's part of the basis for us to say, if that's based on an approval as explained in code, it's hard for us to say then, yes, let's pay it based on a denial and further delaying the project construction here. I do think that we'll provide some additional thoughts in our statement of position, just so we can provide a complete context for our thinking around that, and how do we do that, and how do we actually determine impacts from a project? What would the impact be? And if for example, the impact is concern about fire resources, if the county doesn't fund the volunteer fire departments, would paying that fee even address that particular impact concern? So I think that'll all be provided in our statement of position so that we can provide a thorough, thoughtful response on that.
Yeah, I guess, Mr. Bell, my suggestion would be to have Ms. Chester in redirect provide that commitment document, and then either as part of the direct or as part of commissioner questions, have your witnesses respond. Would that be an okay way of proceeding for you?
I appreciate that, Commissioner, and I'm gonna have to circle up internally with with our clients just to make sure that that's feasible. I can't really take a stance as to whether or not we're going to object to a document we've never seen before. But I would say that at a very minimum, allowing county witnesses to address the commitments letter would be good. But I would also maybe perhaps carve out the possibility of allowing the county to spend some time with this commitments letter, specifically if it's very detailed, and provide either comments or its insight directly to the PUC, or at a minimum exchange it with Excel. But that's kind of our stance now. And I wish I could provide you a yes or no, but I've never seen this document, so I have no idea.
Ms. Caliendo, I'm gonna suggest we break for lunch now. Would you be willing to provide the document to the parties and commission council?
Yes,
So
it
they
is,
could look
it's
at it.
going out now.
Okay. All right, let's take a break till 12:45 and we'll reconvene after lunch at 12:45. Does that work for you, Mr. Bell?
Yes, thank you, Commissioner.
All right, 12:45. Thanks all. All right, we're back on the record, 25A-0354E. Mr. Bell, are you out there? Let's continue with redirect Ms. Cayendo. Sounds like you sent the document to the parties. Is that correct?
Yes, we did.
Mr. Bell, any concerns with this process?
A couple, Commissioner, and I think Mr. Kaufman, my colleague, is going to jump on to walk through kind of the concerns that we have currently. So I will surrender the floor to Mr. Kaufman.
Mr.
Yeah,
Kaufman.
just a second. Yeah, thank you, Commissioner. I guess just starting with a question about, what it is that you're looking for from the county. We certainly have looked at the document. We probably like a little more time to review it. But I guess it's not clear to us, what the question out of this document is. I mean, there's certainly things in here that we don't find objectionable. But I also don't think it really addresses the main impacts to the county that we've discussed in our filings. So if the question is this a sufficient basis? Does this address all the county's concerns? The answer is pretty clearly no. I mean, our concern, as we've reflected in the testimony, is with the particular route, with running up through our economic development zone, running through near neighborhoods or planned neighborhoods, running up our scenic viewshed on Highway 86. Those are more fundamental things, which I don't mean to imply that the things in here aren't good, and that the county wouldn't appreciate those as part of a much broader discussion of the impacts. But I'm not really sure what the commission's asking, if we're saying, is this a sufficient basis or not, or you're asking something else?
I just think we're asking the company to put in one place what it's willing to do, given that the commitments it made in its filing are not binding. So we're just trying to understand, for purposes of building a record, what the company's willing to do, rather than have the commission and the parties sort it out, piece by piece. And we may have questions, if this is admitted, we may have questions for the county. But I don't think there's any assumption that this is somehow sufficient. I think we're just trying to clarify the record.
Yeah, no, and I think if that's all it's being offered for, like I said, there aren't elements in here, although, we didn't have a ton of time to look at it. So I think we'd like to reserve our right. And maybe if it comes in tomorrow and we identify that, hey, here's this bullet point that we think just doesn't really make sense, we'd like the opportunity to say that. But, at first glance, these things don't appear objectionable. And certainly some of these things are positive for the county. So as long as it's the commission is asking what the company might be willing to do, I don't think that we object to this document coming into the record, or the commission asking questions about it. I just want to be crystal clear that the county's concerns go a lot deeper than what's reflected in this document.
Perfectly understood, and either on redirect or in response to commissioners' questions, we'll commit to allowing your witnesses to share their thoughts, since but it understood it's being admitted, subject to your comments.
Okay.
Ms. Cayendo, redirect where you'd like to go.
Thank you. Good afternoon, Ms. Chester. I'm going to take us way back to the beginning. Do you recall a discussion with Elbert County Council of the timeline of engagement with Elbert County?
I do, yes.
And when did the company first contact Elbert County regarding the pathway project?
That was early in 2021 when we sent letters ahead of the CPCN filing.
Okay, and are those letters provided as attachment JLC2 to your direct testimony?
Yes, they are.
And those letters were sent in March of 2021, is that right?
That's correct.
Thank you. Do you recall a discussion with Elbert County Council regarding the completeness of the company's application and specifically the pre-application meeting it had with Elbert County?
I do, yes.
And if we could please pull up attachment CP3, I believe that's to hearing exhibit 206. And if we could look at page 2. And in the second paragraph there, under the bullets, there are several requirements that were requested of the company for its application. Is that right?
Yes.
And what did you take away from these requirements regarding the company's identification of a route?
Yeah, so the county and what they were indicating here required a great deal of detail and engineering work around a route, a single route. We had to identify and work with, at the time, the preferred route that we had selected to develop the materials, to conduct the necessary studies, whether that be engineering or biological, cultural resource investigations. So we were taking and conducting that work on a single route to provide the requested information from the county.
Thank you. And as part of this conversation with Elbert County Council, you stated that the company had provided responses to this completeness review. Is that right?
We provided response to the pre-application letter, which is what we have on screen. We also provided comments in response to various county completeness reviews on our applications. Yes.
Okay. And if we could please now see hearing exhibit 102, attachment JLC 6. And Ms. Chester, are you familiar with this document?
I am, yes.
And what is this document?
This is a response document sent to Elbert County regarding their initial completeness review comments provided on our 1041 application.
Okay. And can we please scroll to page 8? And here at the top states section J.11, review comment 2, provide mapping with sufficient detail to determine proposed locations of temporary construction areas referenced in section 2.4.8.2 of the applicant's 1041 permit application. Roman numeral J.11.A. Is that right?
Yes.
And the company provided its response there?
We did, yes.
And how did the company respond to these requests?
Yeah, so as noted in this particular response, we reviewed each comment provided by Elbert County, looked at the application materials submitted, and provided response. In this instance, we also looked at a transmission line 1041 application submitted by a different utility. It's a utility that we were actually proposing to be co-located with, and noticed that there were some differences in the ask for us in our 1041 application than what was required of that other utility in their application. Nonetheless, as indicated here, we pointed them in the direction of the materials that we had provided. I think we haven't really talked in detail about the fact that Elbert County required submittal of 2 applications, a 1041 and a special use review that went through concurrently. And so certain information was required to be provided in each of those applications. In this case, that material was provided in the SUR application, but we also attached it in response here, so it was easier for them to find.
Thank you. And if we could please go to page 38. And then continuing down to 39. And this comment, and I'm sorry, just up a little bit. Apologies. Right there, thank you. So section J15 review comment 14 regarding inclusion of fire mitigation technologies. Is this the company's response to that completeness item?
It is, yes.
And how did the company respond?
So this comment asked about certain technologies that we believe they may have Googled, or I don't know where they got the information, but nonetheless, as noted here, we did provide information on the fact that we have weather monitoring stations. We'll install additional ones in coordination with our wildfire mitigation plan. And those sorts of things. There was also an ask for a certain type of sensor that isn't in use by us currently. We explain that, but also explain what we do use, and kind of addressed each one in this response.
So is it fair to say that these are just some examples of how the company responded to the concerns raised in the completeness review?
Yes, this is one letter associated with the first completeness review comments associated with the 1041. There's a similar letter for the SUR, and then additional comment response documents throughout the permitting process with Elbert County that continued up to the hearings in June.
And the company responded to all comments and concerns regarding the company's land use permit applications?
Yes, we did.
Thank you. If we could please see hearing exhibit 103, attachment JML7, which is the Board of County Commissioners hearing transcript. And if we could please see page 34 at line 24. Do you recall a conversation with Elbert County Council regarding the identification of pole locations as part of the company's application?
I do, yes.
And do you recall a point at the hearing where Commissioner Schrader asked a question on the siting of pole locations here as shown in the transcript?
Yes.
And then if we could scroll down to page 35. And there, I apologize, I'm probably going to mispronounce her name, but Ms. Bakloviak states, yes, there are the pole locations, I believe, were added to the site plan exhibit as well as attachment R therein. Do you see that there?
Yes, I do.
So Elbert County staff confirmed that the company had provided the pole locations.
Yeah, at the hearing, one of the county commissioners indicated that we did not provide pole locations. We corrected that we had the staff reviewer confirmed that and pointed to the direction of where those were located in our application materials, and the county commissioner indicated that he missed that in his review.
Thank you. Yeah, if we could scroll down just a little bit to lines 19 to 20, we have that reference there where Commissioner Schrader states that he had not seen that. Thank you. We can take this exhibit down. Ms. Chester, do you recall a discussion with Elbert County Council regarding the timeline extension agreement executed between Elbert County and the company?
I do, yes.
If we could please see attachment JLC 21 to hearing exhibit 105. Is this the timeline extension agreement and amendment you were referring to?
Yes, it is.
And what was the purpose of this agreement?
Yeah, as we were looking at some things earlier in my cross-examination, something that was pulled up, for example, was a letter on completeness review around the 1041 application. I believe we also saw pulled up the completeness review of the special use review application. We submitted 2 permit applications to Elbert County on the same day. Per statute, jurisdictions are required to provide feedback within a certain time period on those applications, either indicating they're complete or requesting additional information. We received that review of our 1041 application in that statutory time frame, but did not receive review of the special use review application in that statutory time frame. That necessitated us working with the county to either reach agreement on such a timeline extension. The statute requires, the applicant to be agreeable to that and work with the jurisdiction. So either we had to put this agreement in place, or the special use review application would have moved forward based on dates and statute to be deemed not only complete, but also approved if hearings and such were not held in a certain time frame. So we worked with the county to put in place this timeline extension to allow for extended review of the special use review application, as opposed to pushing it through, so to speak, on a statutory technicality.
Thank you. We can take this exhibit down. If we could now see hearing exhibit 401, attachment JF1. And while we're pulling that up, Ms. Chester, do you recall a conversation with Elbert County Council regarding the fire prevention and safety agreement or the fire district form?
I do.
Is this that form you're referring to?
Yes.
And what does this form require?
So that form requires certain information from us as the applicant at the top, an indication kind of upper middle as to whether properties are located within a fire protection district or not. It then notes about some requirements if properties are located out of a fire protection district, which includes a contract. In the case of Pathway in Elbert County, the line itself is entirely located within fire protection districts, so that didn't apply. And then it indicates that we've met with the fire protection district to discuss requirements, and then it's signed.
Thank you. And if we could scroll to the bottom just so we can see the entire document. And this document doesn't require the company to provide the fire district information on, say, artificial intelligence cameras or weather stations or other information?
It does not.
Thank you. We can take this exhibit down, but I want to stay on the topic of the fire district form. What is your understanding from your work with the fire districts on why they would not sign those forms?
As indicated in their referral comments provided to the county, it sometimes was changing messaging. Big Sandy initially indicated they would sign upon completion of the permit applications, and then change to the requirement of the fees. The same is true, similar story with Kiowa. So it seems to me that the forms were not signed because we hadn't agreed to pay the fees that were requested through the Elbert County referral process.
Thank you. If we could please see hearing exhibit 105, attachment JLC 13. I think this is JLC 14, apologies. We could see.
Oh, I'm sorry, what did you say?
JLC 13, sorry. Okay, Ms. Chester, what is this document?
That is a letter from the company to Elbert County's planning manager at the time, responding to referral agency comments that had been passed along to us.
And if we could please see page 13. And scrolling down, I think the third box from the bottom. Is this a comment from Big Sandy Fire District?
It is.
And what did Big Sandy Fire Protection District say there?
The third box, I'm sorry.
Yes. Regarding the fire safety and protection agreement.
Oh, from the bottom, third from the bottom. I was counting from the top, sorry. Third from the bottom, yeah. So in this particular referral comment, Big Sandy indicated that they would sign the form when we comply with the provisions of the 1041 and SUR reviews.
And what did you take that comment to mean?
It's a little hard to tell as written, but we believed that that indicated they would sign the form once the 1041 and SUR permitting process was complete with Elbert County.
Thank you. And are Big Sandy's other comments provided here in the company's responses?
They are, yes.
Thank you. If we could now please see hearing exhibit 105 attachment JLC 19. And what is this document?
That is the PowerPoint slides or PowerPoint presentation that we offered to the Board of County Commissioners at the hearing in June.
Thank you. And if we could please go to page 14. And what information was provided here relating to those specific requests for information from the fire districts?
Yeah, so this addresses, or this slide is speaking to the county-specific wildfire mitigation plan for Elbert County that we put together. This talks to kind of the items around construction, emergency response planning, also our operational wildfire mitigation plan, refers back to our state wildfire mitigation plan. Also talks about, again, certain things like the Pano AI cameras, like weather stations and sensors that were asked by the county and the fire districts. And so we responded here and provided information about those as well.
Thank you. And at the hearing, was it your understanding that the primary concern from the fire district that had not been resolved was the payment of impact fees to those districts?
That's my understanding, yes.
Thank you. If we could now see hearing exhibit 102, attachment JLC 8. And do you recall a discussion with Elbert County Council as well as Commissioner Plant regarding those impact fees?
I do, yes.
Okay. And what is this document?
So this document is one we submitted to the county responding to the staff report, the county commissioners hearing staff report and rationale for denial of our applications.
Thank you. If we could now please go to page 38. And what is shown here in this attachment A to this response?
This is attachment A is a more direct response to Big Sandy's comments related specifically to the fees that they ultimately requested or required us to pay.
And what were some of the concerns expressed here regarding that impact fee?
So as noted here, a number of concerns, beginning with the way that the fee is calculated based on a height of a pole, not just the footprint, but the height of a pole. Again, discussion that the pathway line is already in a district, and then really the ability and constitutionality and statutory restrictions on implementing such fees and how that would be required to be done for them to be fees that we would be required to pay, and goes into an analysis kind of further down even regarding an intergovernmental agreement between Big Sandy and Elbert County and assessment of such types of impact fees, and how that study actually concluded that facilities such as this shouldn't be subject to a fee.
Thank you. If we could scroll down now through 39 and on to page 40. And if we could look at this last paragraph there, starting with Xcel Energy, What was the company stating here?
Yeah, we were stating here that we certainly wanted to work with the county and the fire districts to ensure that impacts of the project were appropriately addressed, but that we needed to do so as a regulated utility within parameters of the U.S. and Colorado Constitution and state statutes, but also in interest of protecting our customers. We wanted to ensure we weren't paying fees that either were not legally implemented, or that we were paying for the same impacts twice. And so when we saw the Elbert County impact fee or cost of construction fee here, and heard the comments from the fire districts and Elbert County that they saw those as being important and needed to address, we indicated here that as we've said before, at the time, the $2.5 million construction fee was in play, and we thought that that would cover any of the impacts that the fire districts had, and that Elbert County could elect to provide funding to those fire districts out of that fee.
Thank you. We can take this down. Switching gears now to the company's routing analysis. If we could please see hearing exhibit 105, attachment JLC 20. And while that's being pulled up, Ms. Chester, do you recall a discussion with Elbert County Council regarding the Eastern Review area?
I do, yes.
Okay. And if we could look at page quickly, what is this document?
This is a document also provided to the Board of County Commissioners during hearing in responding to public comments and commissioner questions at the hearing.
Thank you. If we could look at page 6, please. And do you recall a discussion with Elbert County Council about this map?
I do, yes.
And looking specifically on the area that Elbert County Council had highlighted, approximately where it says Elbert, and particularly the EL, how did the company go about identifying links to study in its routing and siting process?
Yeah, as we looked at areas, either study area, initially focus area, as the routing study progressed, we looked at and gathered a great amount of data. We mapped that data to the extent it's geospatial, evaluated other data to determine what constraints there might be in an area, to identification of lines on a map, to identification of links. So when we talk about we evaluated or studied so many square miles of area, that really means we mapped resources in that entire area and looked for opportunities to draw alternatives on maps or links on maps that we could further evaluate and take out to the public for feedback.
So is it fair to say that just because there is not a link identified in a particular area, that that area was not considered?
I missed the first part of which way your question was worded, but if there's not a line on a map, that does not mean we did not evaluate or consider that area.
And do you recall a discussion with Elbert County Council regarding the number of routes shown west versus the number of routes shown in the east?
I do, yes.
And what factors contributed to a higher number of potential links in the west as compared to the east in the company's review?
Yeah, in kind of the west, or we'll call it the west, in the west area, a number of things that we looked for in identifying transmission links to further study included things like whether there are existing linear facilities to be located adjacent to, or that can include existing transmission, existing distribution, gas pipelines, highways, roads. It also considers natural resources, location of homes, zoning designations, and so on. And so here in the western area, you can kind of see on the map the white lines. There's more road network here. which provides access for construction and maintenance and operation of the line. It's also an existing linear impact that we can evaluate to be co-located next to. And then in the eastern part of Elbert County, where there is the Eastern Review area, and including that gap even that we were just talking about, that is the highest concentration of conservation land in Elbert County, through either private conservation, formally designated lands like the state wildlife areas, the National Natural Landmark, and so on. So some of those things do not present opportunity for routing transmission through. There's also fewer roads in this area, so it's hard to be co-located adjacent to a road for construction access and maintenance. There are also other facilities out here, and so things like wind turbines, wind farms present a challenge for routing in terms of how close we can be to the turbines, for them to bring in replacement parts and those sorts of things. So there are a number of private airstrips and other things that led to really barriers to identifying lines on a map further east than where there are more to the west.
Thank you. And I believe Elbert County Council asked you about a route along County Road 150, I think the number was. Did the company evaluate such a route?
Yeah, 150 is the road that runs kind of east-west from Agate up near 70 to the west is I believe the one that was being asked about in that kind of area where there are no links shown on this map. And so we studied the entire area in there, and again, noting just the amount of conservation land that exists in this area, jumping cow, state wildlife area, other state held land, private conservation lands, and so on, as well as some homes and airstrips in that area. We were not able to identify a line on a map along Highway 150 or County Road 150, excuse me, given those constraints.
Thank you. We can take this exhibit down. Do you recall a discussion with Commissioner Gilman on the company's specific processes in identifying and eliminating links?
I do, yes.
If we could see attachment JLC1, and I apologize, this is a big document, so it may take a moment. But specifically, you were discussing with Commissioner Gilman the company's link modification tracker and comparative matrix. Do you recall that discussion?
I do, yes.
If we could please go to page 109. And scrolling down a little bit here, I think maybe onto the next page at 110. Is this the link modification tracker that you were discussing?
It is, yes.
And this, for the record, continues on to page 118. And then can we please go to page 119? And scrolling down here to 120. And is this the beginning of the comparative matrix of various links that the company evaluated?
It is, yes.
Thank you. If we could now please see attachment JLC 27. It may take a moment to fully render, but Ms. Chester, what is this document?
This is, it's actually was created as a board that we had at some public meetings to help address questions that we had regarding the routing process. And so on the left-hand side, there are a number of common questions we were getting, and we wanted to provide answers to those in a way folks could kind of look at the board and read it and think about it and ask us questions. In the center is a very busy map that shows a lot of information that we had to consider in identifying alternatives and ultimately selecting the preferred. This isn't all data, but it's a good representation of things that often influence the location or selection of a link. And those numbered squares correspond to the regions that we were answering questions about on the left-hand side. On the right-hand side is the legend about what is all of that crazy data that's shown on the map.
Thanks. And is it fair to say that this map summarizes the link modification and comparative matrix data from the routing study in attachment JLC1?
Yeah, it provides a high-level review or summary of that data relative to some of those bigger constraints that I just mentioned. So we talked earlier about the training areas that were a factor. Those are on this map. I've mentioned conservation lands, formally designated, and private conservation areas that are set up. Those are shown, and you can see kind of how those are concentrated in that eastern area. I talked about existing infrastructure like wind turbines and how that can influence routing, other transmission lines, linear infrastructure like pipelines and other things. We also mapped on here dots around stakeholder comment, where we were provided comment and we're able to kind of tie that to a location. I've mentioned, of course, air transportation, not only the training areas, but there are some fly-in, fly-out type areas and other municipal and private airstrips here. And then roads being important for us for construction access and maintenance and operation of the line, and being located close to those not only limits impact for construction, but also increases ability to respond in case of emergency. And we've talked about how we take care of those during construction.
Thank you. We can take this exhibit down. Do you recall a discussion with Chair Blank on the commitments that the company is willing to agree to?
I do, yes.
If we could pull from the company's box.com hearing exhibit 121. And is this the commitments letter you were referencing?
Yes, it is.
How did the company develop this document?
So we developed this document in pulling together information regarding, call it commitments, as we do in the title here, that we would make. I think Commissioner Gilman described it as kind of 3 buckets, things that we would just do as a matter of course, things that are best management practices. And then in this particular document towards, throughout and maybe even towards the bottom, there are some items here related to those conditions suggested in staff report if approved by another entity.
Thank you. And can you describe some of the commitments in this document?
Yeah, so the first set here, as we scroll through it, the first, I think 2, 3, 4 bullets maybe, are related to our use of county roads for and during construction for haul routes. The fact that we will improve them as necessary, that we'll repair them if they're damaged and restore them at the end of construction, providing obviously the opportunity if a county has to perform emergency maintenance based on damage caused by our use, that we would reimburse for such damage. A discussion about nuisances here in the 3rd bullet. And as we continue to scroll down, maybe we see some items here related to restoration. So restoration requirements for us exist in a couple of different forms. Our agreements with landowners are one place, and coordination with landowners. If it's in agricultural use, prior to construction, then we would restore it in a similar manner. If it's pasture at the time of construction, then it would be restored as such. So our landowner agreements certainly inform that. And then also any state required stormwater management plans or requirements also inform our revegetation and restoration requirements. We talk in the middle of those 2 bullets about our vegetation management standards for public service and as related to federal standards and requirements, as well as what is identified in our state approved wildfire mitigation plan. We've talked about some BMPs. Towards the bottom of this page are items related to coordination with local fire departments and other first responders or fire districts, including providing training and working on construction and emergency action plans prior to the start of construction. There was a request or a potential condition of approval in the Elbert County staff report, which is related to the last bullet here, about informing the county and the fire protection districts of our construction schedules and where we'll be, and providing updates. So we're indicating here we would certainly do that in ongoing coordination with those entities. And then I think moving to the next page, we get to maybe some additional ones, maybe if we can scroll down.
Please scroll to page 3. Yeah.
Again, some additional requirements related to any hot work or welding permits that might be required from the fire districts. There was a request for us to include a wildfire staging area in the construction yard. We previously indicated we'd do that. We're saying we would continue to maintain that agreement here. We indicated in our hearings that we would provide OEM and fire districts access to the Pano AI cameras that we have. And we're reiterating that commitment here and have reached out to those entities to see if they'd like to get access to the camera system data. Remote monitoring is kind of towards the bottom of this, hours of operation during construction and so on.
And just for completeness, if we could see the last few commitments here.
Yeah, and those are primarily related to construction, things like temporary lighting and applicable noise standards.
Again, if we could just see page 4 also.
It's a lot of bullets, isn't it? Compliance with state federal laws are noted here. An agreement to work in good faith to obtain construction related permits, continue our very strong relationship and coordinating with wildlife agencies, including Colorado Parks and Wildlife and Fish and Wildlife Service, regarding any necessary pre-construction wildlife surveys and best management practices. Elbert County had a request to coordinate with their Public Works Department when using the county roads, and then CDOT when using state highways, which we're agreeing to there. And then, if applicable, we would obtain necessary spill prevention, control, and countermeasure plans and permits.
Thank you. I move for admission of hearing exhibit 121.
Subject to the comments made by Mr. Kaufman earlier today, and with the expectation we will solicit comments from the county witnesses. Any objection, any further objection, Mr. Bell?
With that very accurate summary, Commissioner, no objections.
So moved.
Thank you, Chair. And those are all my questions.
Thank you, Ms. Chester. Appreciate it.
Thank you.
Mr. Kuratek, even though we just did this a couple weeks ago, can you please hold up your hands?
Yes, sir.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do, sir.
You can put your hand down. Is anybody with you or communicating with you in any way?
No, sir.
That changes, will you let us know?
Yes, sir.
Back to you, Mr. Manchel.
Great, thank you. Can you confirm someone that you can hear me?
We can hear you.
Okay, thank you. Good afternoon. Please state and spell your name for the record.
Sure. My name is Patrick Kuretich, and that's Patrick, Patrick, and then Kuretich is Kuretich.
And by whom are you employed and in what capacity?
Employed by Excel Energy, Excel Energy Services, and I am the Director of Wildfire Strategy and Performance for Excel Energy.
And did you sponsor hearing exhibit 106 and an associated attachment in this proceeding?
Yes, sir, I did.
That's in the record, and so Mr. Kuretich is available for cross-examination.
Mr. Kaufman, I have 30 minutes. You're up, sir.
Thank you, Mr. Chair. Mr. Kuretich, my name is Gary Kaufman. I'm one of the attorneys for Elbert County in this matter. Thanks for taking the time to answer some questions. I will be fairly brief. To start, Mr. Kuretich, you would agree that operation of high voltage transmission lines can spark fires, right?
I'm sorry, I would say that again.
Would you agree that operation of high voltage transmission lines can spark fires?
I would say there's no history in Elbert or from an Excel Energy perspective of that occurring.
Okay, well, I'm just asking if a possibility, because if they don't have any fire danger, then I don't know that I have any questions.
I would say there's a record in California or other public records that could speak to that.
So are you saying that there's never been a transmission line fire caused?
I didn't say that at all. I said there would be public if you were to look to say California, for example, I think there's a matter of public record for anything on the transmission side.
I'm not trying to be tricky here. I really am just trying to understand, the scope of questions that I should be asking. So there is a record of fires, not getting into the level of risk or what a company may do. And there's also some fire risk associated with the construction of high voltage transmission lines. Isn't that right?
I would say that any sort of construction, regardless of, take high voltage lines aside, right? If there's any sort of construction going on, there may be some elements there that could be subject to wildfire.
Okay, that's all I'm asking. But we can both acknowledge that there's many things that the company can do to mitigate these risks. Is that right?
I would say there's many things the company is doing. I wouldn't say could do. Okay. I would say is doing.
I don't mean to imply that they aren't. I'm just asking. Yep. And so one of the things that the company can do is to work closely with local fire districts. Isn't that true?
I would say coordination with fire districts would be one part of that.
Okay. And you'd acknowledge that local fire districts play an important role in mitigating risks of transmission line related fire, wouldn't you?
Well, actually, I would say the mitigation of fire from the transmission lines is more on the mitigation measures of preventing the fire from happening in the first place, not from the first responders.
Yeah, I understand there's other things that they can do, but so you don't think that they play an important role in mitigating the risk of transmission fires, do you?
I think the fire departments play their role of if a fire were to occur. I think the prevention of fires in the first place is due to the measures in place by the utility and their operating practices.
Okay, so just to be clear, the role of the fire districts would be to put the fire out once it occurred. Is that right?
I think it's the role of the fire districts that if something were to occur in their county as they would today, if there were anything that would happen today, that is in their purview. At least that's my understanding.
Okay, that's all I'm asking. And would you also acknowledge that to ensure that they can successfully play their role in mitigating risks, the local fire departments need to be adequately resourced?
I would say that I guess I'm not sure how to answer that. I think it's up to the fire departments need to look at their resourcing, mutual aid, and other items and determine is that sufficient for the territory in which they operate.
Right, and that's all I'm asking. So it is a factor in how successful they can be is their level of resources. Is that right?
again, I'm without knowing, you know, I guess there's a lot of different factors there. I'm not sure how best to answer that.
Okay, well, let's move on. Could we pull up hearing exhibit 106? And Mr. Koretich, this is the rebuttal testimony that you submitted in this matter. Is that correct?
Yes, that is correct.
Okay. Could we turn to page 16? Maybe scroll down so we can see the whole map. Thank you very much. And this is a map that you included in your testimony discussing different levels of wildfire risk in Elbert County and some of the surrounding counties. Is that right?
This is a map developed using our methodology within our wildfire mitigation program for use on our transmission and distribution assets within Colorado.
Yep, and this map identifies different tiers of risks. Is that true?
Yes, that is correct.
Okay, and the colors are a little funky on my screen, but as I looked at the map on the paper, the red area is tier 3 risk, meaning the highest level risk. Is that right?
Yes, that is correct.
Okay. And the orange area is tier 2, meaning moderate level risk.
Yes, and I guess maybe to finish that out, the yellow would be tier 1, which is considered the low risk.
Okay, thank you. That was going to be my last question about the color. So I appreciate that. And the pink line represents the company's preferred route for the Power Pathway project through segment 5. Is that right?
That is the proposed route, correct?
Okay, thank you. And based on this map, the preferred route runs primarily through tier 1 areas, but also crosses at one point through a tier 2 area. Is that correct?
I would agree that it's traveling primarily on tier 1 with the line crossing some tier 2, correct?
Okay. And that tier 2 area is near the town of Kiowa. Is that correct?
You know, without the city on there, I guess I couldn't tell you one way or another.
Okay, well, we can just agree the map sort of speaks for itself.
Okay, understood.
And would you agree that by moving the line further east, the line would be further away from tier 2 areas in the western part of the county?
Well, I guess maybe two things, right? I would agree that it would, if you move the line further east, that you would be further from tier 2. I think and I'm not sure, maybe Ms. Chester covered this earlier, but that would also put you further, I would say, from first responder type access. I know there was some different things provided by staff showing response times. So I think you end up kind of with a bit of a conflict there when you look at right, the risk shown on this map versus perhaps what might be first responder ability to access, which I hear as a concern. I mean, I guess we've heard as a concern of the county.
Yep. I'm glad you pointed that out, but do you think it's unreasonable for the county to be more concerned with wildfire risk in the more populated western part of the county than the risk in the less populated eastern part of the county?
I guess I don't want to speculate what the county is thinking, but I think I guess maybe we've said this before, and if not, I'll say it again, right? We're a responsible owner and operator of the line, so that, you know, regardless of the terrain in which we're crossing, right, we have mitigation measures in place, and we'll continue, and actually already have lines in that county which we own and operate, which aren't a burden to the county. So I guess I'm struggling a little bit with the wildfire risk of the line when historically we don't have a history there, and we have numerous layers of defense in place to keep that from happening.
Sure, I understand. And I'm just asking you if you think it's unreasonable for that to be a factor that the county would consider when they're evaluating the risk associated with this particular line.
Again, I don't want to speculate for what's reasonable or not reasonable for how the county should feel.
Okay, fair enough. I don't have any other further questions.
Thank you, Commissioner Plant. Questions?
Thank you. Good afternoon, Mr. Kretich.
You got it.
I got it right?
Yes. Victory. All right. What can I do for you, sir?
Even a broken clock is right twice a day. So I just had a couple of questions about the cameras.
Sure.
Piano cameras, and I saw that in addition to some financial requests, the Big Sandy District was requesting, I think, cameras on each of the towers. And I was wondering, as when you look at each of the cameras, do you calculate a sort of a perimeter that they can view through your software and identify fires based on that perimeter, sort of an area as it relates to the topography and all that sort of thing?
I don't think there's a calculation for that. I think there's different ways that, our meteorology and our situational awareness team will look at that. And, again, based off terrain, the height of the tower, things along those lines, to help us determine, how much we can see. What's been, I think, fortunate is we've been getting a lot, I would say, real world now that as we've installed these cameras, and unfortunately fires do happen, we've been able to pull data in. And so we've seen upwards of 40 miles. Interesting enough, there was a fire in Elbert County Tuesday, right? There was I'm trying to remember the name right now, and it's escaping me, but one of the cameras in our network actually picked that up, and it picked it up at about 24 miles. There's some nice pictures of that were used by different fire agencies. So no probably straight answer as far as like what one camera might see versus another. But again, we've seen upwards of 40, if not more, when it comes to not just seeing the fire, but helping to triangulate it. Sorry, go ahead.
Yeah, no, I'm kind of trying to, it seems to me that, probably just a calculation of one camera on every tower isn't, is a little bit redundant, but I'm trying to think of if you do identify if there are blind spots, for example, modeling out what the camera can see from a certain location. If there's any blind spots, you would need another camera somewhere else, or if that kind of determination is done as you're deciding where along a route you might need cameras and how often you might need them.
Yeah, and again, I might be bespeaking. I'm not directly involved in those calculations or what those pieces. There's no understanding, but there's not necessarily a strict calculation for that. I think you're correct though that putting these on every tower is not the intention of a Phantom camera, right? I mean, when we look at these are smoke and wildfire detection cameras. They're really designed to be on at very high areas. I mean, if you think of a transmission line, honestly, you would have to place it below the phase conductors, right? So it really would have this almost no value on the tower itself because you'd have to place it so far below the phases. Then I'm not going to get the vista that the camera is really relying on for that smoke and AI detection.
Do you don't generally put them on the actual towers? You put them on some other structure? Is that?
Yeah, correct. Right. I mean, really what you want is, you want like very high vistas, right? I mean, the goal is, how do I get panel, right? I want that panoramic view. So, putting it on a transmission tower that is going to be I'm going to put it 40 feet off the ground. It's really not going to give me much visibility. I'm going to look at other towers, maybe their radio or other different things where I can put that 100 feet up, 150 feet up. So I can really start to get a good wide view. It'd be really, maybe you guys should get some access to the camera so you guys can kind of see what the cameras can see. It's actually a very, very cool technology. But I think as we place them through the wildfire mitigation plan, right, we're really trying to get that area on tier 2 and tier 3 specifically. But what we're finding is the benefit of the camera is far exceeding you know, that range. And so again, no strict calculation. If the cameras we have along Elbert, for example, we have some that are within 9 miles of the line. And others that I think the furthest point might be somewhere between 28 to 30 miles, which again, we've seen distances beyond that we're picking up fire, or not just picking up fire, but triangulating, right? That's another important piece of the camera is we're not just one camera finding it, it's one camera and you have enough others in the region that are also able to triangulate that to give you a very precise location of that fire. So it's helpful, I guess. I'm going down a couple of rabbit holes here. But.
Yeah, no, this is really interesting for me. So, in addition to that, and you mentioned there was a fire earlier this week. Do you currently have sort of a communication protocol established, or some sort of a relationship established with the fire districts in the Elbert County area? I mean, we talked about 3 of the fire districts in this. Do you have some sort of an agreement or relationship sharing that information with them now?
To my knowledge, I'm not sure we do have something in place for them now. I know we have, if you go back to BOCC hearing, for example, we offered the cameras up, and we've actually, I re-followed up right after the fire saying, hey, we actually have camera footage of this, and this was in the network, and there was other entities within Colorado, and I think one of the main Colorado fire entities who has access, I think, it takes that information and pushes it on to other districts as well. So I mean, I would say there's multiple state agencies that have access that are coordinating with others in that as well. So to my knowledge, they're not using it today. We've offered it. I offered it again, and I guess I would maybe. I mean, to me, I think it's a valuable tool. Like I obviously it's up to them to sign up for it. We did hear back from Tri-County today, as actually one of them. Tri-County responded back today that they would like access. So we're expecting Tri-County to send some email addresses to us, hopefully in the next week, to get them up and running on it. So maybe one of the 3 in the next week, we can get them up and running. It's a very easy. We're talking an email, and they just have to sign up for an account. It's a very easy process.
Okay. And do you know if you have an existing relationship with the emergency services in the county, or emergency responders, not necessarily the fire department, but
that I don't know. That's a good question. That's not necessarily my area, like on the communication side. I mean, it's certainly something we can get you an answer to at some point, but I don't know which OEMs that we're plugged into, you know, in Elbert or those surrounding counties offhand.
Okay. That's really helpful. Thanks. That's all the questions I have.
Commissioner Gellman.
Thanks. Just really brief questions from me, Mr. Kurtik. Happy good afternoon. Happy afternoon. Okay. I just wanted to kind of follow up on the discussions on the potential for further east route that's been discussed, but like relate that to the fire discussion more specifically. Am I correct in understanding that the company generally sees the kind of the risk or profile as similar, but some differences in response time capabilities likely further east? Or help me just understand the interaction.
Yeah, I think, you know, I've looked, just reviewing some of, I think they came from county staff. They had produced some response maps, right? It kind of shows what might a typical response be, or what, you know, is it a 5 or 10 or, you know, 15 minute, I forget the intervals. And you see that really kind of dying off as you go out east. And so it really just, I guess my comments were more around, it's not as simple as, well, the map shows higher risk here, so move it over here, right? There's a balancing equation, I think, even in that. Again, we're just talking even wildfire risk. I mean, Ms. Chester talked extensively about all the other things you have to consider with routing. So wildfire is, I guess, one piece of the puzzle. And even within that piece, you kind of have to also look at, well, as I move it over here, the response is less, right? Which have heard from the county is a concern, right? You know, they've said we don't have enough resources today to even deal with existing fire risk. So I don't know if that answers you. That might have been a long way of saying I think it's just two different things to consider, a bit of a balancing equation when you talk about the wildfire portion only of permitting that route.
Okay. Thank you. Those are my only questions, Chairman.
Thank you. I don't have any other additional questions. Redirect, Mr. Manchell.
Yeah, just really one question from Commissioner Gilman's questions there, just for helpful record evidence, if the commissioners are so inclined. Can we please open up hearing exhibit 102, attachment JLC 7? Go to page 31. Sir, is this the map of response time capability you were referencing between kind of different western or eastern portions of the county?
Yeah, this is exactly what I had pictured, right? And I think you just, as you can kind of look at the map, you can see further west, right, we have more fire departments. You have that infrastructure as well that, offers that what appears to be, at least by the map, some better coverage, right? And the further you head east, that coverage starts to fall off, and the amount of fire departments and infrastructure starts to kind of, at least by the map, starts to kind of thin out.
Okay, no further questions. Thank you for being here. Thank you for your time.
Thank you.
Thank you, sir. You may be excused. Let's see. Is the first county witness, I'm not even going to try and pronounce her name, Blakayawak. Can you hold up your right hand, ma'am? There you are. And you're on mute. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down. Is anybody with you or communicating with you in any way?
No.
If that changes, will you let us know?
Yes.
Back to you, Mr. Bell.
Thank you, Commissioner. Ms. Blahoviak, I think everybody is excited to hear how you pronounce your last name. So could you say your name and spell it for the record, please?
My name is Stephanie Blahoviak, and I spell that Stephanie, Blahoviak, B as in boy, Lochowiak.
Where are you currently employed?
I am currently employed with SWCA Environmental Consultants.
And what is your job title at SWCA?
My job title is Principal Natural Resources Team Lead.
Did you submit testimony in this proceeding?
Yes, I did.
Can we pull up hearing exhibit 200, please? Thank you. Ms. Blahoviak, I have just put in front of you what has been referred to as hearing exhibit 200. Is this the answer testimony that you submitted on behalf of the county?
Yes, it is.
And if I asked you the same questions today, would your answers be the same?
Yes.
Ms. Blahoviak, seeing how there were no objections in hearing exhibit 200 is a part of the record, Ms. Blahoviak is available for cross-examination.
Thank you, Ms. Cayendo. I have 30 minutes, and you can take the exhibit down.
Thank you. And good afternoon, Ms. Blahoviak. My name is Lauren Caliendo, and I am counsel for public service in this proceeding. And I will try very hard to pronounce your name correctly, but apologies in advance for when I inevitably screw it up. You were hired by Elbert County in February 2024 as a contractor to provide review of public services 1041 and special use by review, or SUR, applications, which I may refer to collectively as the company's land use permit applications. Is that right?
SWCA was engaged at that time frame for the 1041 review, and then there was a change order issued to add the SUR. That was later that year.
Thank you. And in this matter, you developed 2 staff reports regarding the company's land use permit applications. Is that right?
Yes, 1 staff report, well, 4 staff reports, I suppose, technically. There was one for the 1041 for the Planning Commission hearing. There was a staff report for the SUR for the Planning Commission hearing. There was a staff report for the 1041 for the Board of County Commission hearing, and a staff report for the SUR for the Board of County Commission hearing. So.
And you have not been involved in any other 1041 or special use by review applications in Elbert County, is that right?
In Elbert County, no, other than this project in question.
Thank you. If we could see hearing exhibit 200 and page 12, line 6. And your review of public services and land use permit applications was for compliance with Elbert County Code. Is that a fair summary?
My review used the Elbert County zoning regulations.
Okay. Did you consult with legal counsel employed by Elbert County or your own legal counsel in conducting your review of the company's land use permit applications?
The member of the team was Chris Price, as well as the Elbert County attorney at the time, and I do not recall that person's name. That's a different person today.
Okay. And just to confirm, you consulted with them as part of your review of the company's land use permit applications?
Yes.
Thank you. If we could now scroll down to line 21 through 23 on the same page. And you state here that you reviewed the company's applications against the county's 1041 regulations, county regulations, Colorado statutes, as well as the Elbert County Comprehensive Plan update. Is that right?
Yes.
If we could please see hearing exhibit 112 in the company's box.com. Is this the Elbert County Comprehensive Plan that you were referring to in your answer testimony?
Yes, that looks familiar. It is the same one that is on the Elbert County Planning website.
Thank you. I move for admission of hearing exhibit 112.
Any objection, Mr. Bell?
No objection.
So moved.
Thank you. We can take this exhibit down. And if we could come back to hearing exhibit 200, please. This time at page 17. And then here on lines 1 through 18, you state that in your review, you determined that Public Services 1041 permit application failed to meet Elbert County's code relating to natural hazards. Is that right?
Yes.
And specifically, the natural hazard was wildfire risk. Is that right?
Yes.
The company provided Elbert County with both an Elbert County specific wildfire mitigation plan as well as its statewide wildfire mitigation plan. Is that right?
The company provided a document titled Project Specific Wildfire Mitigation Plan or some such. We can pull up the actual submittal document and that would be helpful.
Okay. Did you review those materials that were provided?
Yes.
Okay. So regarding the company's Elbert County specific wildfire mitigation plan, is it correct that you provided examples to public service representatives to follow in developing that Elbert County specific wildfire mitigation plan?
The company requested an idea or an example go-bys for the request. It was a little bit of a surprise to me that they were struggling with what would be included in a project-specific wildfire mitigation plan. However, in the spirit of collaboration, examples were provided from a project that I was aware of where there was a similar situation, in that there was a state entity that had a process that is for public utilities and lines, as well as a state that's a home rule state that allows for local government land use regulation and jurisdictional control through tools such as a conditional use permit or special use permit. And so that was an example I provided that seemed the potentially most similar, not exact, obviously, to Colorado, and the most similar to sort of the regulatory situation framework that we were operating within.
Thank you. If we could please see hearing exhibit 113 from the companiesbox.com. And scrolling down a little bit, is this the email from you to public service representatives providing those example wildfire mitigation plans?
This appears to be an email from me dated April 15th, 2025 to Excel Energy and Stephanie Phippen, the Tetra Tech representative, that provides links to examples. Yes.
Thank you. I move for admission of hearing exhibit 113.
Any objection, Mr. Bell?
Yeah, can we scroll to the second page, please? No objection, Commissioner.
So a minute.
Thank you. If we could come back to the body of the email, that first example hyperlinked there, one of the examples you provided to the company was from Oregon for Idaho Power. Is that right?
Yes.
If we could now please see hearing exhibit 118 from the companiesbox.com. And this I'll represent is a copy of that Idaho Power Draft Fire Prevention and Suppression Plan from Oregon that you sent to the company. Does this document look familiar to you?
Yes.
I move for admission of hearing exhibit 118.
Any objection?
Can we scroll through it, just the first couple pages, please? Thank you. I appreciate it. No objections.
So moved.
If we could look at page 5 of this document, just kind of guide our discussion here. So this is the table of contents for this fire prevention and suppression plan, which includes fire prevention measures, including training, smoking, spark arresters, parking, vehicle operation and storage areas, equipment, road closures, refueling, burning flammable liquids and explosives, communications, welding, and fire suppression, as well as restricted operations and monitoring. Is that right?
That appears to be what the table of contents says.
And this document also contains a section regarding operation and maintenance. Is that right?
Yes, this document was an example that was provided as a starting point for the applicant to try to draft a project-specific wildfire mitigation plan for Elbert County.
Thank you. And if we could scroll now to page 10. And scrolling down a little bit here. The section 2.0 fire prevention measures, and then scrolling through to page 14, this details all of the various fire prevention measures contained in this example wildfire mitigation plan. Is that right?
Yes, that looks correct.
And if we could go to page 14, taking fire suppression here on as a specific example, this describes the specific actions to be taken should a fire occur during construction, right?
That appears to be what this section is referencing.
Which includes attempting to extinguish the fire, contacting fire response agencies, and notifying the contractor and the utility, which in this case is IPC or Idaho Power Company. Is that right?
That appears to be what are you speaking to 2.1.12?
Yes.
Yes, that appears to be accurate.
Thank you. If we could now see here in Exhibit 105, Attachment JLC 18. And this is the Elbert County Specific Wildfire Mitigation Plan and the cover letter of that plan. Is this document familiar to you?
Yes. Can you scroll down a little bit on that first page? Yes.
Okay, thank you. And if we could go now to page 9. Which may look a little bit familiar. It shows a table of contents for this Elbert County Specific Wildfire Mitigation Plan. And specifically looking under Section 2, fire prevention measures includes training, smoking, spark arresters, parking, vehicle operation and storage areas, equipment, road closures, refueling, burning, flammable liquids and explosives, communications, welding, and fire suppression, as well as restricted operations and monitoring, correct?
That appears correct in the table of contents that you are showing.
And below, there's a section 3 regarding operation and maintenance. Is that right?
That appears correct.
And if we could look now at page 16. And scrolling down a little bit here to the fire prevention measures, included in this fire prevention and suppression plan. And for comparison's sake, if we could go down to page 21. Under section 2.1.L, fire suppression. This describes the specific actions that should be taken should a fire occur during construction, right?
It says fire suppression, pages 53 and 54 of the emergency response procedures, attachment C, includes the contractor's fire suppression activities should a fire occur within the project area during construction. K, in the event of a fire, the following steps will be taken. 1, notify first responders. 2, notify QISG/Excel leadership. 3, notify Excel Security Operations Center with I think a phone number. There's a typo maybe there for that phone number. 4, notify PAR leadership. 5, if the fire is manageable, use tools and equipment to extinguish. 6, if fire spreads or becomes unmanageable, move all personnel to safety zone. And additional training materials regarding fire prevention and mitigation are provided in pages 5 through 25 of the emergency response procedures, attachment C.
And so as shown here, the company provided this information similar to what was provided in the example that you provided to the company, as well as additional information contained in attachment C to this document. Is that right?
The company in 2.1.1 or I'm not sure what that is or L, I'm not sure what that's saying. The company provided inserted information or referenced other information submitted in the application in this section in the wildfire mitigation plan, which is anticipated. I would anticipate that this wildfire mitigation plan that's project specific would reference other information, cross-reference and align with the information that was provided related to emergency response. I think that's a good sign.
Thank you. And if we could scroll to page 128 of this document. And this shows here attachment C, emergency response procedures. Is that correct?
Attachment C, emergency response procedures is what I'm seeing.
And these were the referenced emergency response procedures from the section we were just looking at, right?
Can you scroll down, please?
And I'll represent that this attachment continues through the conclusion of the document on page 218. So we can scroll, Ms. Bolkowiak as much as needed, but.
That's fine. So to answer your question, yes. And the continued frustration from staff was that we continue to ask for specifics to the proposed project route and to Elbert County specifics in particular. And the information submitted was a lot of, like we're looking at right now, is very generalized information and not specific to, for example, the temporary construction areas, the proposed route, the communications and coordination with the specific personnel of the fire districts, the specific locations of the cameras that are apparently in existence, where those are located, why are they located there, how do they assist the company and management of fire prevention, management, asset management, risk assessment, as well as the specific locations of, for example, it sounds like there's existing weather stations as well that are used. And then in addition, the analysis informing why there would not need to be additional cameras added in locations in response to the proposed route or weather stations, why we wouldn't need to add weather stations in a specific response to should the project proceed and be constructed.
Is it fair to say that the Elbert County specific wildfire mitigation plan resembles the Idaho Power example that you provided?
It is fair to say that there are similarities, and it is fair to say, in my opinion, that the example provided was not the end all be all, and that it was not created or ever intended to be exactly meeting the Elbert County regulations. It was simply the company seemed to be struggling with what to do and how to submit project-specific wildfire mitigation plan information that's specific to the permits in question. And it was a good faith effort to try to assist them in a speedy process. We were rushing to hearing and trying to help them.
And isn't it true that the company provided additional information, such as the emergency response procedures in attachment C that we're looking at here, beyond what was shown in the Idaho Power example?
It appears that the company did do that, and it was information that was duplicative that had been submitted in the permit applications, preliminary emergency response information. Again, it's a very high level generalized information. A lot of the information could be also found on public facing website and marketing material, sort of general statements of almost value statements, I guess. And what we were looking for were the specifics. and more detail. And that's a theme throughout a lot of the asks that we're making, was, we really want to get into the weeds, and this was the opportunity and the time and the process, in my opinion, to get into the weeds on the details of a proposed project and why decisions were or were not made in the design as relates to the questions that the Office of Emergency Management had from Elbert County, as well as the special fire district questions, again, related to, sensors and cameras, and how does that work, and how do you make those decisions, and what's the engineering that's involved, and where are the locations, proposed or definitive. We will be adding cameras here. This is why. We will not be adding cameras here. This is why not.
Thank you, Ms. Bohoviak. Those are all my questions.
Thank you. Mr. Larson, I don't think I saw time for staff, but maybe I screwed that up. Mr. Larson, did you have a question or a comment?
Oh, well, in any event, I was going to waive our time anyway. I thought we did have time, but I could be mistaken. My apologies.
All right. Well, if you did, it's waived. If not, no need. Thank you. Commissioner Plant, questions for the witness?
Yeah, I just had a couple of quick questions. Good afternoon, Ms. Wozniak. Did I get close?
You're close. Good job.
For me, you're going to be the witness. Sorry.
So you had mentioned that the special use review was added to the process. What is it that triggers a special use review?
Added to the process. Can you clarify, Commissioner Plant?
Yeah, when you were just talking with the counsel from the company, I thought you said that you were going through the 1041 process when the special use review was added, and so then you followed that. But if I got that wrong, please correct me.
Oh, yes. It's just a really technical way of explaining for the original contract that was put into place was specific to the 1041 application review, and the original contract did not make mention of the SUR application review, and therefore when Elbert County approached us to also ask to review the SUR application in addition to the 1041 permit application, that simply necessitated a contractual change order agreement with Elbert County in order for us to be engaged to review the.
So it wasn't added from the county side, it was just added to your plate, basically, is what you're saying.
Correct. Yes, Commissioner.
Okay, gotcha. And the impact fee, as I understand it with the SUR, is based on a percentage of the total construction cost? Is that how that's derived?
I would like to pull up, I believe there's an exhibit that, well, I don't know the name of the exhibit. However, I do know that there's a fee schedule page that is posted on the Elbert County website. I can picture it in my mind. However, I think it would be helpful to pull that up.
Yeah, I'm not sure what that is, or if somebody knows what it is, or you can pull it up. But is it basically within this range, it's this percent, within that range, it's that percent? It's already a set sort of schedule. Is that what you're saying?
That is my recollection, and I'd feel most comfortable if we pull up the actual document.
Yeah, I'm not sure if anybody knows what that is. Mr. Bell, I don't know if you have any idea what document.
I myself am looking. I will let you know once I find it.
Yeah, we can move on. I was curious about that.
Commissioner, if I find it, I will try to bring it up on redirect.
Yeah, great. No worries. Thank you. And I'm sorry, Ms. Dundas, did you have a
No, I'm not sure it's even appropriate to speak, but I believe Ms. Blockwick is referring to the fee schedule in Resolution 2239, which I also cannot find in the record. So if it is there, I'd also be interested in knowing where.
If it helps, I'm intending to introduce it. I got it marked as a hearing exhibit, so that may tee it up for redirect Commissioner Plan. I don't think it is in the record, but it will be before redirect.
Okay, sounds good.
Or at least I'll try.
Okay, and I saw that the amount the Big Sandy Fire District was requesting was a price per square foot of the line, and then also per 10 vertical feet, I think, of towers. Do you know what that would come out to, or a ballpark of what that, or is it just sort of?
That, Commissioner Plant, that's a great question, and that is not my lane. I don't.
Okay. Well, if there were some dollar amount that were agreed to based on their calculation, would that come out of the impact fee and the SUR, the percentage fee? Would
No.
that portion of that go to the fire department? So that would be assessed separately?
Correct, Commissioner Plant. I'm sorry to interrupt. It is a separate, in addition to fee that is squarely the special district's fee, that's in addition to Elbert County. And that's, in my experience, a pretty typical arrangement in local government, private land use planning and development.
Okay. And that's usually a condition of the SUR, is that having that agreement done. I think in this case, it's called a fire protection safety agreement or something like that. That's a part of the SUR, but the fee is sort of.
That is a good question. My understanding is that I'm not sure that it's only part of the SUR. That's why I would like to pull up that page that I mentioned, that fee schedule. And I just don't recall if that's specific to the 1041 permit or the SUR permit or both.
Okay. Well, maybe we can clarify that when we get to the chair's questioning and he brings up that document. But those are the only questions I had, Mr. Chairman. We can move on.
Thank you, Commissioner Plant.
Did you call on me or?
Yeah, I'm sorry, Commissioner Gilman.
Okay, no, maybe I missed it. I was actually kind of inclined to let you go first because I'm interested in this fee schedule situation. I have some questions about the fees. Seems as though you may have something that's helpful to me. If not, I can go first. But
no, I'll go first. I'm happy to go first. Can we pull up hearing exhibit 200 attachment SAB 13? And I think this is a report evaluating public service companies' special use review application for the Board of County Commissioners. Do you recognize that?
June 3rd, PC hearing date, BOCC hearing date, June 24. This is this must be the Board of County Commission staff report for the SUR in particular.
Correct. It's an attachment to your testimony. Can we turn to page 16? And if you could scroll down, do you see 3 all applicable fees listed in Elbert County Resolution 2239?
3, the applicant shall pay all development and development review fees and additional costs at least 6 months prior to the start of construction. And these include the following. Oh, this is in the section that's recommended conditions of approval in the event of future project approval. all applicable fees listed in Elbert County Resolution -22-39. B, third-party professional review fees. C, impact fees. D, SUR, wind farms, solar farms, pipelines, power installations, and transmission lines of $20,000 $20,000 plus 2% of the total cost of construction. And E, all applicable impact fees assessed by special districts. Yes.
So let me ask you a couple of questions. Did the county have the Public Utilities Commission in mind when it talked about in the event of a future project approval, or did you have something else in mind?
That is an excellent question. I've never been in this situation, to be perfectly honest, and I was not sure who the ultimate decision maker would be or become, if not Elbert County, BOCC. And this was my attempt to try to provide, if a decision maker was trying to come to a decision on this application, these two applications, what my professional planning recommendations would be for conditions of approval if and when the permit applications were approved. I did not know, truthfully, who the final decision maker was going to be. It's still not clear to me who the final decision maker is.
Okay. Keep this up, but if we could also pull up hearing exhibit 601, which I believe is a copy of the resolution we've been discussing, 2239. And if you could just scroll down all 4 pages, and subject to later check, would you have any reason to doubt that this is the resolution you referenced, if I represent to you that I just pulled it up by Googling it and going to the county website?
This looks familiar to me. This is what was in my mind. Thank you for providing it.
Well, let me represent to you, advisors did it. I didn't, or counsel. All right, can you just scroll up just a little bit? That's good. That's good. And do you see the 7th bullet labeled wind farms, solar farms, pipelines, power installations, and transmission lines? Do you see that?
Yes. This appears to be, which is what I was hopeful for, this appears to be the text that I was referencing, and it appears to align with what was included in those suggestions for conditions.
Mr. Bell, do you have any objection if we admit this in the evidence just to help clarify the record?
No objections, Commissioner.
So admitted. All right, and so the company says that if under that 7th bullet, I think that 2%, $20,000 plus 2% of the total cost of construction comes out to roughly 2.5 million. Does the county agree with that number, have an alternative number in mind, or just doesn't know?
Chair Blank, I am not the person who would have that answer. I don't know.
Of the witnesses, do you know if there's someone I should ask, or just ask one of the county commissioners?
I believe the county commissioners would be the best to respond to that.
Okay, thank you. You might keep this handy, but if we could go back to hearing exhibit 200, attachment SAB 13. So looking at 3C, where it says impact fees, is that completely separate from D, which I think is the $2.5 million estimate from the company, which I guess the county may or may not agree with, but independent of how we quantify D, do you view C as entirely separate from D?
Potentially. And the reason is that we were not able to, I was not able to understand what impact fees might be associated with road impact fees in particular. And for Elbert County, I am simply not aware of the Road and Bridge Department process for assessing those fees. And it was a fail-safe, I guess, to make sure I didn't miss any additional impact fees.
So 3C we should view as road impact fees, and maybe the document the company provided can help quantify that. How about 3E? Is that sort of the fire? I mean, do like the fire districts have the ability to do that? How would that get implemented and quantified, and when and by whom? It's a complicated question, but break it down as you see fit before your attorney objects.
It's a great question. Chair Blank, that's a great question. And I was not specific in 3E, and but I did have in mind the two fire districts in particular who appeared to have legislatively adopted impact fee schedules. That was the Big Sandy Fire Protection District and the Kiowa Fire Protection District. Now, there are other special districts certainly that are along the proposed route. However, I did not hear from other special districts, for example, school districts. Special districts, there's all kinds of special districts all over the state of Colorado. It could be a special water district, it could be a school district, it could be a special transportation improvement district or metropolitan planning organization. In this case, I only had in mind, I didn't specify fire districts, but I just, again, fail-safe impact fees assessed by special districts. In this case, the two that I know about, am aware of, were the special impact fees that were applied by those two fire districts, those two special fire districts.
Okay, so can you help me figure out, so just looking at 3 as an integrated whole, it says the applicant shall pay all development and development review fees and additional costs. Can you help me? I guess is there a number quantified anywhere on this record about what this would be? And if not, can you quantify it for me now? Or is there another witness that could help me quantify it?
There is not, to my knowledge, a quantification in the record of these fees and a total, line item and total. There was simply not time to get there, and it just didn't progress to that point. So and can I do that? I cannot. The economists often are the ones that will do that, or internal, county attorney, board of county commission. That is something that I'm not familiar with. I can't offer that disagreement and fights, if you will, about development fees, including impact fees and special district fees, are a pretty common fight across the United States in development on private land. If that's helpful, it's not an uncommon thing to fight about.
Not as helpful as I was hoping. Well, any advice to how it gets quantified? I mean, the companies before us arguing 3D should be zeroed out. That I'm struggling with that, to be honest. but
Here, Blank, I do know that there are firms in Colorado who specialize in this type of local government accounting, I suppose, for lack of better way of saying it. I'm venturing out of my area of expertise. And I know that, I think I know in Colorado that there are actually some pretty good guidelines for how to mark these out and line item them and arrive at the total. There are specialists who do this.
Well, I mean, I think this decision is going to have to be based on evidence in this record. Wherever it goes. That's all I had, Commissioner Gilman. If you want to jump in, and Commissioner Plan, if that hasn't answered your question, I'll give you a chance after Commissioner Gilman. So, Commissioner Gilman.
Yeah, thank you. That actually answered a few of my questions, but now I have new questions. So I may be making a few of them up on the fly, but hopefully they make sense. You had identified as the potential for another impact fee, which would be that 3C category from the document we were just looking at. Or do you recall what I'm talking about?
3E spoke to the
3C, C as in cat.
The 3C that simply said impact fees.
Yep. And so you'd indicated one potential impact fee could be like a road and bridge impact fee. Do you remember that?
Yes. Potentially.
Yeah. I was curious if that's applicable, if the applicant or is committing to ensuring they return any of that infrastructure back to its original condition.
Excellent
like if they are
question.
already committing to foot the bill for that, would that be, in your experience, in lieu of a road and bridge impact fee?
Commissioner Gilman, different local governments will do it different ways. And I would encourage us all to revisit the Elbert County zoning regulations to see if they provide input and guidance on that. That's what I would do if I was going to take a deep dive. I always default to what do the statutes say.
Okay.
Or I would ask the Board of County Commission for their input on that. I do not know in this instance for Elbert County specifically.
Okay, so you're just not aware of any specifics around impact fees that might be implicated by letter C as in cat?
No specifics. I can tell you that other districts often will have a formula for transportation impact fees or road improvements fees and a schedule.
Okay. And when, in your experience, when are those fees normally identified? Would those be identified after approval of an application or some time prior?
Those, in my experience, is often around the time of the road use agreement and or development agreement. That's when the specifics are coming into play. Ideally, in an ideal world, there is a calculation, at least like a rough order of magnitude that can be provided during staff comments throughout the process prior to hearing. That's an ideal world, though. That certainly does not always happen.
Okay. Let me just see a couple of my questions. This is probably a question for the county themselves or the commissioners, but looking at the $2.5 million impact fee that's already been discussed and referenced, do you have an understanding upon, I mean, I understand the percentage upon what it's based, but do you have an understanding in terms of proxy for what impacts in particular that is based?
I can provide a general answer. I would prefer the Elbert County Commissioners to, if they can and want to, get into the details on it. Generally speaking, and there was earlier today, there was sort of the question or kind of issue raised of impact fees versus property taxes. What I think I know is that impact fees for development project are a one-time fee to make sure that local governments, the authority with jurisdiction is taking into account the potential impacts and adjustment in services and public infrastructure that might need to happen in response to a new proposed development project, and to offset that cost so that the existing residents, business owners, developments that are already in place are not inordinately, it's not lopsided, and they're now sort of tasked with providing services to this project that they didn't know was coming or they didn't have say in, essentially to offset your impact, right? It's a one-time thing. And then the property taxes are for an ongoing operations and maintenance of services over time. Let's say police services, public roads and maintenance, et cetera, et cetera.
Okay. Thank you. Let me just see. I'm just double checking other questions I have. The chair might have already asked this, but are you aware of any document in the record that references the relevant fire protection district impact fees and any calculation or basis of those or dates those were provided?
The only thing that I am recollecting is the schedule. So the I think that Chair Blank mentioned it. I don't recall if it was in there, the fire district comments during the referral comment period, or if it was during I know they communicated it. Is it in this record for this hearing? I'm not recalling where that would be, but it was the Chair Blank mentioned the pole height and I think the number of poles, et cetera. Whether there was a final total number, if I'm understanding the question correctly, I don't recall ever seeing a final number based on that proposed schedule.
Okay. And then I just wanted to understand, changing gears a little bit, a little better, kind of the difference in view, at least that I'm hearing, between the county and the company in terms of if all of the required information was provided. And so just to be clear, I think the county's identified in some of their reviews certain information that they believe still needs to be provided. The company has largely testified that much of that, if not all, was provided, and then they just referenced you back, the county, back to where that was provided. So I guess looking at specifics, you went through a list with Ms. Caliendo when she was questioning you of additional detail, for example, that the county wanted regarding the project-specific wildfire mitigation plan. And I was curious, was that specific feedback, like those exact items you mentioned, provided in writing in response to the company's application? And then did you receive any response to that?
Yes. we could pull up I think it was 4 different completeness review letters that were provided for each application for the SUR and the 1041 between December and April, I believe. I believe the completeness review letters and company responses are part of this record for this hearing.
Okay, I'm happy to take a look. I just trying to follow all the threads and know where to look to understand the differing points of view here about if all of the requested information was in fact provided by the company. So it's your position that still as we speak today, the company has not provided information that the county identified in writing was necessary as part of their permit.
That is correct.
Okay. Those are my only questions. Thank you.
Commissioner Plant, did you have any follow-up, or did we get your questions answered?
I got my questions answered. Thank you.
I'm going to propose a break before we do redirect. Did you have something, Ms. Shields?
No, I forgot about redirect.
You're jumping to the
But
next
a break
witness.
sounds great. I will happily take a break.
Well, I appreciate the over-eagerness. Thank you. Let's take a break till 2:55, and we'll come back with redirect. 2:55. Redirect, Mr. Bell.
Thank you, Commissioner. Ms. Blahoviak, well, I want to be sure that, let me just double check to make sure that the county attorneys are online. Or excuse me, the company attorneys are online. Perfect. All right. Base is covered. All right. Ms. Blahoviak, the company attorney spent some time with you, what has been referred to as hearing exhibit 118, which was, and we can pull that exhibit up just to make sure that our, yeah. Do you recall the line of questioning from the company attorneys regarding this document?
I think I do.
And correct me if I'm wrong, this was a document that you provided to the company, is that right?
Correct.
Okay. And what was the purpose of you providing this document to the company?
The purpose was to respond positively to a request from the company team, the permit application submittal team, to get an idea of, what are you looking for a project-specific wildfire mitigation plan. After there was I don't remember what date it was, but there was a virtual meeting about the third round of completeness review letter, or the fourth round, I forget. And the specifics that we were looking for, the company cited the statewide wildfire mitigation plan, and our response sort of was, well, that's for the state. We're concerned with Elbert County. We want to focus on Elbert County, and specifically, this project, and along this route in particular. So can you provide a project-specific wildfire mitigation plan that presumably would be aligned with that sort of master plan, that state master plan, and then let's get into the specifics for this project. And we had that meeting, and I don't remember if it was during that meeting or after, in an email, a request of, can you provide an example? And I thought, well, I could try. And it wasn't a apples to apples example, but it was something.
Yeah, so you didn't intend for this to replace Elbert County requirements, did you?
No. And in retrospect, maybe it was not actually helpful. Maybe it just confused things.
But you testified that your intent was to use this as a starting point, and that it wasn't an end-all be-all. Is that right?
Correct.
And this wasn't intended to replace the company's obligations to collaborate with local fire divisions. Is that right?
Correct.
Okay. And then relatedly, this wasn't intended to replace the company's obligation to execute fire protection and safety forms. Is that right?
Correct.
But what is the purpose of a fire protection and safety agreement form?
Generally, when there are forms such as that come from special districts, the goal is to signal to the planner and the authority with jurisdiction that the applicant has coordinated with those districts to make sure that the districts are aware of the project, they have reviewed the project, they are okay with the proposed specifics of the project, the route. For example, let's say there was a ditch that needed a ditch crossing. It's pretty common to make sure, okay, did you talk to the ditch company? Because what you don't want to do is you don't want to be a local government that ends up approving something that you didn't have authority to approve, such as a easement over a ditch or impacts to a ditch, when that's really not your jurisdiction. that's just kind of big picture. In this instance, in my view, others can disagree. Typically, a fire form like this is to make sure that the fire districts have been included in decision-making and review, that the applicant has talked with them about any local specific regulations that they've adopted. They might just go with the ICC International Code, something, ICC regulatory or NFPA regulations, but they also might have some local specific regulations, requirements. Ultimately, from a planner perspective, I'm just looking for the special districts to sort of give the green light. And that's usually what these forms do. They provide a signature and say, we are in agreement. It's okay to make a decision on this project. We've talked to them. We've worked on the specifics. We sign off. And in this case, fire districts in particular, it's sort of planning 101, that one of your main goals is it's all based on public safety, health, welfare. And so fire and emergency response is directly related to that. So of all the special districts, in my opinion, fire districts are, if we had to rank and prioritize, I would say they're at the top as far as who you want to make sure you have on your team and have buy-in from and support and sign off.
Sure. And in your experience, what does it suggest to you if an application is submitted without a completed fire prevention form?
It's extremely unusual, I would say. It is unprecedented as far as I am concerned with applications I've been involved in. And it suggests that there was not resolution to in-person meetings that were had, or conversations, virtual emails, referral comments were not satisfactorily addressed in the view of the special district.
We can put this exhibit down. Thank you very much. Commissioner Plant, as well as I believe Commissioner Blank, asked you a lot about impact fees, specifically trying to delineate the various impact fees. In your experience, what is the purpose of impact fees requested by a local fire division?
Sure. The local fire division could assess impact fees in order to make sure that new developments as they come in are, paying their fair share into the bucket, if you will, of the needs for capital improvements, for example, or capital expenditures. So maybe, contributing a percentage to, let's say they need a new firehouse in a new location, or they need, they've got a gap in access to water tanks, so maybe they want to install a new above ground or below ground. Rural areas often will have these above ground or below ground water storage tanks, 30,000 gallon tanks or so, for fire response in remote areas. So maybe they're, that would be a capital expenditure. So they are collecting impact fees, a percentage to go towards that capital improvement. It could be capital resources, maybe could include personnel. It is often, though, kind of a little more tangible. Maybe a new fire truck is needed, or to fix the fire truck, or maybe they have a fire truck for urban areas, but they need one for brush fires that can go over on uneven terrain, things like that. So it wouldn't be fair to have, one applicant responsible for the whole capital expenditure, but it's pretty typical to have a kind of a percentage so that, you know, as developments come in, they're all kind of adding to the bucket of what's going to be needed as development comes in over time. Typically what we see is, you know, development brings more development in more often than not. So, you know, there's development, then it's just kind of a way to over time make sure that you've got the capital fees to help, you know, provide the services.
To your knowledge, are there any separate, aside from impact fees, to your knowledge, are there any pending concerns from the fire divisions that remain unanswered by the company?
I believe that the
objection beyond the scope of her testimony.
I'm happy to respond, Commissioner, if allowed.
Yeah, please.
Yeah, on cross-examination, there was a great deal of effort spent in terms of comparing what the company provided to the county versus what, you know, I think there is a general line of questioning regarding the sufficiency or the adequacy of the information provided to the county. And I think this question directly goes to the sufficiency and adequacy of the information provided to the county and whether or not there are any pending concerns expressed by the local fire divisions.
Overall, you can answer.
Would you like me to re-ask the question, Ms. Blahoviak?
Yes, please.
To your knowledge, are there any pending concerns from the fire divisions that remain unanswered by the company?
Yes.
The last thing that I wanted to bring up, and it's more just clarification for me than anyone else, but can we pull up Exhibit 200 SAB 13, please? I believe Commissioner Blank pulled this up and had some questions for you. Can we go to page 16, please? We scroll down. So subsection 3 underneath recommended conditions of approval in the event of future project approval. We spent some time going through the subparts to 3. For subsection D, is that an impact fee or is that a 2% construction fee?
I would simply read the resolution. And so the resolution, I believe, calls it a construction fee.
I have no further questions. Thank you.
Thank you. The witness may be excused. Commissioner.
Yeah, can you give us 5 minutes to set up the next witness?
Yeah. Probably not going to take 5, but we're swapping out Ms. Blahoviak for Commissioner Buck.
Yeah, let's just when Mr. Buck, Commissioner Buck turns on his camera, we'll get started.
Okay, sounds great. Thank you.
And Commissioner Blank, correct me if I'm wrong, but we have a hard stop at 4 today. Is that correct?
4-ish. Not quite a hard stop, but we are going to break early.
Okay. Well, I will rush to get the witness set up.
That'd be great. let's just take a break till 3:15. 3:15. Hopefully that's
I
enough.
apologize for the technical difficulties.
Yeah, no worries. Commissioner Buck, can you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Put your hand down. Is anybody with you or communicating with you in any way?
No, sir.
If that changes, will you let us know?
Yes, sir.
Back to you, Mr. Kaufman.
Thank you, Chair Blank. Can you please state your name for the record?
Mike Buck.
And Mr. Buck, Commissioner Buck, where are you currently employed and in what capacity?
Elbert County Commissioner, District 1.
In this case, did you cause to be filed hearing exhibit 201, answer testimony of Mike J. Buck?
Yes, I did.
Do you have any changes to your answer testimony?
No, I do not.
If I asked you the same questions today, would your testimony be the same as reflected in hearing exhibit 201?
Yes, it would be.
With that, I'd make Commissioner Buck available for cross-examination.
Ms. Shields, I have 45 minutes, I think. 45 minutes.
But I'll see if I can beat it. Good afternoon, Commissioner Buck. Thank you very much for being here.
Yeah, thank you for the opportunity.
My name is Caitlin Shields. I am counsel for Public Service Company of Colorado, also known as Xcel Energy. Now, I understand you have been an Elbert County Commissioner for just over a year. Is that right?
That's correct.
Okay, and I believe you were elected in November of 2024 and sworn in January of 2025.
That's correct.
Okay. Is it fair to say this is one of the first major land use decisions that you've been involved in as commissioner?
I would not the first major land use, I would say, but first major transmission line for sure.
Is it fair to say this is a fairly controversial project for Elbert County?
Fairly controversial.
Now, in your testimony, in your answer testimony, you state, I understand that no route is perfect and that there will be some impact on the county and its residents, no matter the route that is selected. Do you recall that?
I don't recall that.
If we could pull up hearing exhibit 201, this is your answer testimony. Page 26. Starting at the back. Reading down lines 10 through 13. I understand that no route is perfect and that there will be some impact on the county and its residents, no matter the route selected. There are certainly better options than the one that the company is trying to force on the county.
Okay.
Do you recall that testimony?
That sounds like something I would say. Yes, I do recall that.
Okay.
This discussion there is the impact of this particular route is catastrophic to the county.
Understood.
And there is areas that would be less impactful.
Okay. And so would you agree though with the basic premise that, any potential route is going to involve some trade-off and impact? In other words, there's no zero impact option.
Yes, there's degrees of impact always.
Okay. And when you say that there are better options, the county has not proposed a firm, clear GIS mapped routing alternative as part of its case in this proceeding, has it?
It has not. It's not our burden to be a site. I'm not a site professional, a siting professional. That is the obligation of the applicant to provide the site plans. That's not the county's obligation to do that. You're shifting the burden to the county.
Okay. And now when you say you're not a siting professional, though, I understand that you have a background in, or an extensive background in real estate development. Is that right?
Correct.
Now, if we could move to page 21, I have a few more questions about your testimony. And in this section of your testimony, you raise a number of concerns that you have about public services engagement with the county, correct?
I do.
Okay. And in particular, I'm looking at lines 6 through 7, running down through 21 through 24. You indicate the company was not willing to collaboratively engage with the county to find an acceptable route. And then you go on to state that as you understand it, the company made a final decision on the route they wanted for the proposed transmission lines through Elbert County toward the end of 22, and then held meetings for the next couple of years where they basically said the route had been decided, so we are not going to talk about it.
Correct.
And that is still your testimony today.
Correct.
If we could move to hearing exhibit 105, this is the rebuttal testimony of Ms. Chester, and if we could open that to page 13. And while we're opening this, Commissioner Buck, this is at page 13. I'll begin representing to you. This is a list of the public meetings and agency meetings that the company held related to segment 5 for the Pathway Project. And do you see in here that the dates range from June 2021 through March 2025?
I do not.
Okay, and you do not dispute anywhere in your testimony that these meetings occurred, correct?
No, I don't see it coming through 2025.
Okay, if we could scroll down just a little bit, I think it just might be there.
Okay. Yeah, I see it now.
Okay, thank you. So approximately 4 years, correct?
Correct.
If we could turn to page 15. And this graphic here, this represents the routing history for segment 5. And Commissioner Buck, just for my own foundational awareness, have you been listening in on the hearing today? I appreciate your okay, good. Now, together, this exhibit combined with the last reflect that the company held 23 public meetings for segment 5 with over 1,000 open house attendees. And you have no reason to dispute these figures, right?
No, I have no reason to dispute the figures, but the feedback coming from those meetings was the route had already been decided.
Understood. At least that's your personal opinion.
That's
great. Your personal conclusion. Now, as you also look at this, particularly, I'm looking at some of the information in that lower bar. Are you aware that the company considered over 4,000 square miles for segment 5?
I didn't know the exact
Okay, but you have no
mileage.
reason to dispute that.
No reason to dispute it.
Okay. Now, are you aware, looking in the kind of second from the right yellow box, that in the summer of 2022, the company expanded its study to include a full additional Eastern area study that included Eastern El Paso County?
Yeah, I'm aware of that. And Ms. Chester's written testimony is that there was mixed reviews coming from the Eastern Review area, whereas the preferred route has negative reviews and feedback from the citizenry.
Sure, and I believe it was also her testimony that the company spent 7 months specifically studying that Eastern Elbert County route. You have no reason to dispute that, correct?
I don't dispute that, but she also said in her testimony that it was a mixed review and response from those people that attended those meetings.
Would you have expected a unanimously positive review
No,
at any public meeting?
but we did have a unanimous negative on the current route.
Okay, in the county's perspective.
Well, I don't think the company has provided any instances where they've changed the route or made any recommendations based on any recommendations from those meetings that were negative to make any adjustments.
Okay, and so just to be clear though, have you reviewed the full record in this proceeding? Have you reviewed Ms. Chester's testimony, including the 1041 permit application and all of her attachments?
Some of it.
Okay. Now, notwithstanding that the company engaged in 4 years of study prior to you being sworn in as a commissioner, 7 months focusing on Eastern Elbert County, it is still your position that the company was dismissive of the county's concerns. Is that right?
They were dismissive of my concerns. I asked at the meeting, one of the first things I asked was if we were going to be discussing the route. And they said, no, we've chosen the route. I even received a phone call from one of your lobbyists that said the route had already been chosen. There was nothing we could do about it. And I felt that was dismissive.
And in your personal capacity, when you refer to the meeting, are you referring to the June 24th through 25th hearing?
Correct.
Okay. We'll talk a little bit more about that. Now, if we could go back to hearing exhibit 201 at page 21, revision 1, this is your testimony, page 21. You indicate, let's see, I'm looking at lines 10 through 12, and you testify that Public Service likes to point to its routing study, some of which we just looked at, as evidence of collaborative engagement and coming up with the ultimate route. And then you go on to state that the problem is that the process was very Excel driven. I'm a little confused by this statement and by your concern with the process being Excel driven, because in this case, Excel, Public Service Company of Colorado, was the applicant for both of the permits at issue. Is that correct?
Yeah, they were the applicant.
Okay, but nowhere along the line, the county did not conduct its own independent siting analysis or routing study, did it?
No, that was not our responsibility. It was the applicant's responsibility.
Okay, and so nor did the county conduct its own engineering analysis or cost analysis or cost benefit analysis, correct?
We did not, and we would have loved to have heard Excel's cost benefit analysis report. And that came up, and Ms. Chester referenced what you called a PIM, performance incentive metrics. That was one of the factors, was a cost factor. And I would have loved to have seen some of those big boards and gone through a really detailed examination of the different routes, why they were selected, why they weren't selected. This is the additional cost. This is what we looked at, but we weren't afforded that opportunity.
Okay, well, that actually brings up a good point, which is you are aware that the Colorado Public Utilities Commission issued a decision approving a certificate of public convenience and necessity for the pathway project, correct?
Yes, correct.
Okay, and I understand you were not a commissioner at the time that proceeding occurred. However, are you aware that the county did not participate in that proceeding?
I have no knowledge of it. I'm sorry.
Okay, and are you aware that performance incentive mechanism that you're referring to was heavily litigated as part of that proceeding in 2021?
Not aware of that.
Okay. Now back to your statement here on on line 12. Just to close the loop here, the county did not hire SWCA to conduct an independent siting analysis either, did it?
I wasn't involved in the hiring of that organization.
Okay. Okay, and so to be clear, what I have heard from you is that it is your interpretation, your understanding that Excel had the burden here, correct?
As an applicant, yes. Typically, all the applications we've ever seen, it's always the applicant's burden.
Okay, and so by virtue of Excel having the burden, I'm struggling to see why it was a problem that the process was very Excel driven when they were the applicant and had the burden of proof.
Well, they claimed that they worked collaboratively with our citizenry, and I don't believe that was the case.
Okay, so when you say that the process felt very Excel driven, are you really suggesting that Excel was the only party to do any technical analysis?
I would say they did the heavy lifting for technical analysis. Yeah, that's for sure.
Okay, and the county did no heavy lifting or no lifting at all for that matter?
Yeah, that was not our scope of work.
Okay, let's talk a little bit more about the proposed route. If we could turn to hearing exhibit 200, attachment SAB 14 at page 5. And while we are pulling this up, I'll let you know this is the county's staff report prepared for the June 24th through 25th, 2025 hearing, which you were present at. And does this map generally look familiar to you?
It does look familiar.
Okay. And this map is intended to reflect generally the zoning designations within Elbert County. Is that correct?
Correct.
Okay. And it's kind of a pinkish magenta dotted line. Do you see that? That is the proposed segment 5 pathway project, correct?
I do see that.
Okay. And you state in your testimony that one of your most significant concerns with the route is its location, and in particular along Highway 86 and Kiowa Bennett Road. Is that right?
That is correct.
Okay. And it's your position as well as the county's position that the company should have proposed a route farther to the east, correct?
Correct. And the reason being is the economic development zone.
Great. That's where you're getting just one step ahead of me. And I'm eager to come back on that. But when you say farther east, that would mean an area more to the right of the screen in that kind of purplish zone, correct?
Correct.
Okay. And so if we could zoom in just a little bit around Kiowa. Yeah, I'm really just want to make sure that we can that we have yeah, I think that works. Thank you. And so as I look at this, kind of this area running north of Kiowa along Kiowa Bennett Road is an area of concern, and then similarly southeast from Kiowa along 86, correct?
Correct.
Okay. And would you say that particular area of the route is the area that the county or that you have the most concern with?
Correct.
Okay. Now, one of the concerns that you raise is that this is one of the most highly visible and trafficked roads in Elbert County, right?
Correct.
Okay, and then you also raise concerns with the route running along an economic development zone, is that right?
Correct.
Okay, and then I think a couple of the other concerns included view shed impact, wildfire risk, and impacts to ranching and farming, correct?
Correct. And I had a lot of concerns in regards to our underwriting guidelines, rules and regulations.
Okay. Now, particularly on the economic development area, the legend earlier indicated that the green shading reflects economic development areas. Does that look right to you?
The dark green shading?
Correct. And if we need to
Yeah.
scroll over to the legend, we can, but
No, it looks familiar.
okay.
That's where it's at.
Okay. And so what I'm seeing here is where the pink proposed route aligns with the economic development route. It also appears to coincide with and run along existing roads. Is that right?
It sure does.
Okay. And so in this particular area, the area of concern, the economic development zone appears to fall around roadways in and around Kiowa, correct?
Correct.
Okay. Now, are you concerned that by siting a transmission line next to existing roads, it's going to have negative impacts to future property development?
Well, I think that has the largest impact on the view because most people are on the roads. They're going to be driving through the road, driving down the road, if you will. And the biggest visual impact will be from the vehicle. So you're going to see it. And inside that economic development zone, we recently approved, maybe 2 or 3 years ago, approved a couple large residential developments that no one's talked about yet that I've heard, thousands of homes.
Yeah, and so that's one of the areas that I'm interested in because you mentioned the recently approved residential development of several thousand homes in the area.
Correct.
And so what I'm trying to reconcile is how how a transmission line from your perspective will ruin a view shed, but multiple thousands of homes in this area will not have negative impacts.
Well, the economic development zone is for, residential, commercial, that sort of thing, rather than an industrial scar that depletes those property values or lessens those property values.
Okay. Now, are you also aware, however, that Colorado Department of Transportation CDOT has existing right-of-ways in this area and that the company has proposed to co-locate its line with both existing CDOT rights-of-way and existing transmission infrastructure?
See, I thought our guidelines said we preferred to co-locate with transmission lines, not roads.
Okay.
I don't see anywhere in our guidelines where we prefer or to co-locate with roads.
Okay, so instead of locating the pathway project, segment 5 pathway project here in this area, it would be your preference that it move to some kind of more conceptual area out east where there are fewer roads and fewer transmission lines. Is that correct?
Well, fewer people, fewer landowners, fewer structures. We had a fire 2 days ago that if there would have been structures, there was almost 6,000 acres that burned, and we had high winds out there, and we've had a severe drought for the past couple of months. We had over 30 different agencies having to help us respond. Our firefighters are woefully underprepared. They don't have the equipment. They're understaffed, and thank God that was in a area east, and they were able to get it contained eventually.
Okay, well, wouldn't you agree that the areas out east, that response times from first responders are going to be longer in that area out east?
That would be a willing trade-off instead of a populated area. We can pasture grass. I would prefer to burn versus someone's home.
Okay. And I am not aware of any allegations that that recent fires were caused in any sort of way by a transmission infrastructure, correct?
No, I did not say that.
Okay. Now, am I correct that now when you mention that areas out east tend to have lower population, are you aware, however, that there are numerous conservation easements and environmentally protected lands out in eastern Elbert County?
Yes, I am aware of that.
Okay. Are you aware of the Jumping Cow State Wildlife Area to the east?
Correct. Yes, I've heard of that.
Okay. And then I believe that there is a national landmark up to the north as well.
Heard of that as well.
And so are you aware, given your experience in real estate development, that conservation areas and protected lands present significant challenges from a siting perspective?
They could.
Okay. And so it would be your preference that the line move out east and disrupt and impact the view sheds out east rather than impacting the view sheds where the line would currently be co-located with thousands of homes.
Correct.
Okay. Am I right that nowhere in the record the county has quantified the economic impacts from siting segment 5 along these existing roads?
Could you repeat the question, please?
So when you raise concerns about potential economic impacts with citing the line here through these economic development zones, the county has conducted no quantitative analysis evaluating the potential economic impacts from citing the line where we've proposed it, correct?
Not that I'm currently aware of.
Okay. Now, am I correct that at no point during the June 24th or 25th hearing, the developer of that multi-thousand home development appeared and provided comment?
Not that I'm aware of.
Okay, so the very developer that you've been concerned about economic losses or economic impacts to did not participate in the June 24th or 25th hearing, right?
He did not.
Okay. Now, in considering the company's permit applications at that June 24th and 25th hearing, did you consider at all, did you take into account the public health, environmental, and emission reduction benefits that the pathway project would provide?
There's benefits. I'm not opposed to the power pathway. There is benefits associated with that type of energy.
Would you agree that Elbert County residents will benefit from emission reduction benefits from this line being constructed?
I don't know how much emission reduction would take place, so I can't really comment on that.
Okay, so assuming the premise is true that the pathway project will facilitate emission reductions, would you agree that Elbert County residents will benefit from those emission reductions?
Potentially, maybe.
Okay. Do you have any reason to doubt that the county's denial of the permits will impair public services ability to provide safe, reliable, and cost-effective service to its customers?
Can you say that again?
Do you have any reason to doubt that the county's denial of the permit will impair public services ability to provide safe, reliable, and cost-effective service to its customers?
We're not denying the permit, just the location. We have a problem with the location because it's too impactful for the county.
Okay, so in other words,
we want to work collaboratively with the company.
Okay. Now, did you hear Mr. Lunar testifying earlier today? There have been a lot of discussions about impact fees, and so I presume that you have heard some of those discussions today, right?
Yeah, I did hear that. And to be honest with you, I've never calculated the impact fees. That's not my role.
Right.
The CDS director would be able to calculate impact fees for you. That's what they do on a day-to-day basis, along with our county manager, who is our financial director. Either one of those individuals would be able to calculate impact fees. I've never been involved in calculating impact fees for any contractor or for any applicant. So I can't comment on the impact fees.
Okay, and so I think, and this is the last area that I wanted to ask you a question on, but what I'm hearing from you loud and clear is that your concern is with this route. Your
Correct.
concern is not with the fee or with the amount of money, correct?
Correct.
Okay, and so from your perspective, is there any amount of impact fee that public service could have paid that would have made this particular route acceptable to you?
It's not about the money to me. It's not about the money. It's about the route and what it does to our county as a whole.
Thank you. I have no further questions.
Thank you, Commissioner Plant.
I don't have any questions.
Commissioner Goman.
Sorry, I'm checking my notes. I don't think I have any additional questions. Thanks.
Yeah, just maybe one following up on Ms. Shields' last question for you. I guess in the board resolution, it stated that the amount of taxes and fees alone fails to provide Elbert County and its residents with significant value sufficient to outweigh the costs and impacts created by the project. But at least some of the impacts, the wildfire mitigation, and some others may be offsettable by impact fees and constructions. Do you have any advice about how to think about this or how to guide us?
Well, the only thing I can say to that is I did talk to one of the fire chiefs, not from Big Sandy or from Kiowa, but from Elizabeth, and they did let me know that the cost of one fire truck is about $1.5 million. And that 6,000 acre fire we had the other day, there was over 30 apparatus at that fire. Over 100 firemen. They had 30 different agencies all the way from Boulder to Colorado Springs, and that fire was fast moving. And like I said, I'm just thankful that there was no nearby homes or businesses that would have been affected, and it was further out east. Fire is a real concern to the citizens of our county, especially with this dry pasture grass we have out there.
Me too. I'm glad it got put out. Mr. Kaufman, redirect.
I guess I had questions, and maybe I missed this. I thought staff might have cross-examination if they waive that.
They did.
Oh, okay. Okay, and I don't have a whole lot.
Let me just check. Mr. Larson, is that right? Is my cross-examination matrix screwed up, or did you have questions?
I believe we reserved time, but we were going to waive it again. So no harm, no foul, Mr. Chair.
Okay, good. I didn't want to miss out on a critical step in the process.
You're good.
Okay. Commissioner Buck, I just have a couple of questions just to clarify. Counsel for the company talked about some large amount of meeting totals that occurred in Elbert County from 2021 to 2025. Is that correct?
Correct.
And you don't dispute the fact that there were a number of public meetings held regarding the Power Pathway project, do you?
I do not dispute that.
Did you ever get any feedback from Elbert County residents who attended those meetings about what they thought about the engagement at the meetings?
Absolutely.
And what was that feedback?
It was discouraging, Gary. It was discouraging, and the citizens felt like they weren't being heard, they weren't being listened to, and that the company was checking a box, and that the route had been predetermined, and all the other things that went along with that.
Okay. I don't have any other questions. Thank you.
Thank you, Commissioner Buck. You can be excused.
Thank you, guys. I appreciate the opportunity.
Likewise.
What's your preference, Commissioner? We could tee up Commissioner Schroeder for today, or we're happy to come back tomorrow too.
Yeah, let's keep going with Commissioner Schroeder, and we'll see where we go.
Okay. We will have the same witness swap out issues, but hopefully it will be a little faster this time.
All right.
It could be much faster if you guys don't mind us not changing the name on the witness. So it'll look like Commissioner Buck, but he'll look different. Okay, let me get him set up, and it'll be a quick swap out.
Yeah, let's take a break till 3:50. Commissioner Schroeder, can you hold up your right hand, sir?
Yeah, and then just, you can make that big on the right-hand side. Okay.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
You can put your hand down. Is anybody with you or communicating with you in any way?
No.
If that changes, will you let us know?
Yes, I will.
Back to you, Mr. Kaufman.
Thank you, Chair Blank. Can you please state your name for the record?
Dallas Schroeder.
Where are you currently employed and in what capacity?
I am a commissioner in Elbert County.
In this case, did you cause to be filed hearing exhibit 202, answer testimony of Dallas v. Schroeder?
Yes.
Do you have any changes to your answer testimony?
I do not.
If I ask you the same questions today, would your testimony be the same as reflected in hearing exhibit 202?
That's correct, yes.
With that, I'll make Commissioner Schroeder available for cross-examination.
Thank you. Mr. Mansholt, I have a 45 minutes, and if we could plan on breaking around 4:15, 4:10, that'd be great.
Okay, we'll do. We may be able to wrap up the whole thing by then. Good afternoon, Mr. Schroeder. Thank you for being here.
Thank you.
Could we please pull up your answer testimony here in Exhibit 202? And we'll turn to page 17. And we'll scroll down a little bit. And sir, if you can't see something on your side, you can no doubt ask us to scroll around or zoom in or zoom out. We want to make sure you can see lines on the screen that I'll be referring to.
Okay, so far so good.
Okay, great. So right now, I'm just referring to the question on line 13. Here is where you had a question about some of the key reasons for denial of the 1041 permit. You see where I'm at?
Yes.
And in your answer response, let's go to your next page, page 18, and look at lines 8 through 13, the paragraph there.
Okay.
And in these lines, here's where you are explaining that the board denied the permit because the application was not complete, since the company did not get signed fire prevention and safety agreements from Big Sandy and Kiowa fire protection districts as required by zoning regulations.
That's correct. Yep.
Okay. Just laying some foundation there and refreshing your memory of testimony. And you are aware, sir, that Elbert County imposes an impact fee, or I believe the county calls it a construction fee, which would have applied should the county have approved the company's siting permits.
There is a fee for all 1041 permits.
And do you recall that the company estimated that that construction fee would have required the company to pay around $2.5 million?
That seems to be the number I remember being talked about, but I don't know a definite number.
And you are aware that essential reason why the fire protection and safety forms were not completed with the fire districts like Big Sandy is because they have been seeking additional impact fee payments, correct?
Well, the fire protection districts in Elbert County are a separate entity, and so to try and combine those into somehow that the county is over the fire department, so the fire departments exist in conjunction with the fire departments is incorrect. They are their own special district, their own entity. They set and collect their own fees, just as any other entity does, and just like the county does.
Appreciate that. I'm not sure that's my exact question, though. I think what I'm trying to ask is, are you aware of the fact that one of the main reasons why the company did not get those signed forms is because those fire districts are seeking the imposition of additional impact fees beyond the impact fees that the county imposes?
I'm not specifically aware with that at our hearing. We just were made aware that the fire protection district forms were not signed, and for a perspective from us as decision makers, it's important that we have all of these different forms, all these different agencies input and their sign off there, that we've been in conversation, we've been working with the applicant regardless of the project, for us to know that the fire districts are comfortable with the project. And by not having that form signed, that was a red flag.
Could you clarify whether the county funds the fire districts, such as through the impact fee payments that you receive from applicants or otherwise?
No, the county does not fund independent fire districts. They collect their revenue from several different sources, from their mill levy on property taxes. They have their own impact fees, but the company or the county does not collect those and then somehow divvy those up between all the different districts and send it out.
So a hypothetical here, should this Public Utilities Commission require the company to pay an approximately $2.5 million fee to Elbert County, would the county use those funds to support the funding needs of the fire districts in the county?
Well, not directly to the fire districts. They have their own mechanisms for income. The impact fees and the different fees in general that you're being referred to here are for the impacts and the different costs associated with the project for the county. And one of the things that's important to realize is that particularly when we're talking about fire prevention and fighting fires, our Public Works Department is extremely involved anytime that we have a prairie fire, as they take their maintainers, their dozers, and go out and cut fire lines. And we have seen over the years that this is the primary way that we're able to stop such fires, is getting ahead of those and using county equipment in conjunction and coordination with the fire departments to cut fire lines to be able to stop these fires from moving. And so we talk about impact fees, but it's really a fee we don't know what kind of costs over the years, the lifetime of a project this size will cost the county. And so we have to be able to cover those future costs.
We're going to change topics a bit. I believe you stated in your testimony here that you're, quote, very familiar with the 1041 permit application process at the county, correct?
Yes.
Just help me here, kind of from the very start of major 1041 permit process, including the pre-application stage, to its conclusion with a board vote. How long do you reasonably expect that process to take?
Well, it's a variable timeline based on, first of all, how we can get everything scheduled. But from the time that the community meeting is held, a pre-application meeting is held, the actual formal application is submitted to the point where all the referral agencies get back. That's where lots of times we do see a slowdown in the movement of an application, depending on how many different referrals need to go out. When all those referrals have been satisfied and complete, then we move on to the Planning Commission and then to the Board of County Commissioners.
So I appreciate the process stages, but do you have any generalities of timelines? Are we talking months, years, multiple years?
I would say months. I would say months for most applications that I've seen.
Okay. And the company's application process here was about 4 years long, start to finish?
Yeah, that's what it has been, yes.
Okay. Is it your position that the pathway project should have a different route, such as some unidentified location further east in the county?
Yeah, I think there needs to be a route that doesn't go against some of our regulations. And so when we're, as a commissioner, looking at any application, sitting in a quasi judicial role, we have to look at the application as it's presented from what staff presents to us, what the applicant presents to us, and compare that to what our regulations say. And so there's a considerable number of issues with the current route that violates those regulations that would need to be addressed. And the easiest way to address those is to move east.
Okay, let's do a hypothetical on that. Let's assume this commission denies the company's request in this proceeding and directs the company to start all over again and propose a new route in the county located further east. In that hypothetical, how long would you expect it to take from total time to get a board vote on the new route proposal further east in the county?
I'm going to object to that. It's really speculative. There's so many factors that go into how long it's going to take, a lot of which are beyond the county's control. So I think that's real speculation to try and put a timeline on something that hasn't happened yet.
Yeah, it's a hypothetical. He's already explained. He's very familiar. He's already put timelines on generalities. He doesn't know, he could state so, but he may have actually some ideas of this timeline.
Overruled. If you can answer Commissioner Schroeder, that'd be great.
Yeah, I would just be totally guessing, and I have no idea how long that might take. There's so many variables out there to make it very difficult to pin down a specific timeline.
Would you be willing here and now, on behalf of the county, to commit that if the company was required to go back and propose a new route east in the county, that the county would take up the permit and rule on it within the short few months time frame that you previously referenced?
What short time frame was that?
I'm referring to the few month time frame that you referenced previously in your general 1041 total permit process statement.
Well, I'm sure it would go into the regular hopper of projects that we have. If you're asking if that would be expedited, that's certainly not a question that one commissioner can ask. It would have to be something that we would have to discuss as a commission if this was going to be an expedited project or not. And it would be out of bounds for me to answer that question unilaterally.
I think it's clear what you're stating, but just for the record, you can't commit today on your own accord that there'll be just a several month process for a new route proposal further east to be resolved by the county.
Right? It would be inappropriate for me to do that.
And hypothetically speaking, again, even if the company went back and proposed a new route further east before the county, you can't guarantee that the county would in fact approve such a permit proposal, right?
Well, as I've stated, the role of the commissioner is to look at an applicant's documents and what they've put forward in regard to what is said in the regulations. And if all the regulations have been met, then it would follow that the applicant would get approval.
But you can't state today that you actually guarantee approval. It's going to be.
Well, how would I know if there's a complete application in the future at a hypothetical date?
You're stating that you have to do an independent review of every application. That's your testimony, right?
That's what we do, yes.
Okay. I have my last set of questions now. In your experience, does the county treat all applicants for 1041 permits the same and without discrimination?
Yes.
I like to pull up from box.com an exhibit pre-marked for identification as hearing exhibit 109. And this is the board's resolution that approves a 1041 permit for a transmission line by Core Electric back in 2014. As you see here towards the top of this resolution, you were on the board at that time. it approved this resolution, correct?
If you scroll down, it will say if I was a part of the approval process.
I think I see your name there at the top, actually.
That's just who is present at the meeting. So yes.
Okay. And can we go to page 2? If we scroll down a little bit, we're going to look at the section that starts with the bold words of "be it therefore resolved." Do you see that in the middle of the page there?
Yes.
And these 5 conditions are those the board imposed on Corps' 1041 permit for its 2 substations and supporting transmission line in the county, correct?
Yes, that's what it looks like.
And just to look at these 5 conditions, the first one, I'm summarizing. The first one just says to remove the public hearing signs, right?
Yes.
Number 2 is to pay the fees.
Yes.
Number 3 is to get a SRU application approved.
Yes.
4 is have the financial security bond.
That's correct.
And 5 is a site development plan requirement.
Yes, that's correct.
Okay. I had asked the commission to enter this hearing exhibit 109 to the record.
Any objection, Mr. Kaufman?
No objection.
So admitted.
And we can move on and open up the last hearing exhibit from box.com. It's pre-marked for identification as hearing exhibit 108. And this is the actual underlying Core Electric Cooperative's 1041 permit application that we just showed the county, including yourself, approved. And we can turn to page 32 of this PDF. In the top section here, it regards the impacts of the project on local government services. And we're going to focus on the second paragraph. And in fact, we're going to look at the last sentence. I'm going to read out loud. Maybe you can follow along with me. It says the potential use of local fire department services during construction or operation of the proposed facilities will have a negligible effect on the overall capability of responders to provide services, as the project would only need services in the unlikely event of an emergency. Did I read that correctly?
Yes, you did, but you also left out the previous sentence that says that this is a relatively small size of the crews needed for construction. This was a minor 1041, not a major, and so there is a differentiation there.
Okay, and the next bolded section, here's where potential impacts or burdens are addressed. The second sentence here reads that Corps and its contractors will also initiate discussions with the Rattlesnake Fire District staff prior to construction to review emergency procedures, including safety procedures for conducting fire suppression activities near a power line. Again, I read that right?
Yes.
And now we go to page 45. The middle section here has a bold language header about the descriptions of the risks to the project from natural hazards. You're still following along here?
I am.
And the last paragraph, we can get it all on the screen. Yeah, right there. Thank you. And I'm going to, let's see, read and I'm going to focus on the third sentence. Now, last paragraph, I'm going to read out loud. It says, to mitigate the risk of starting a fire during construction or operation of the project, vehicles will not idle in areas of tall grass, and each crew will be equipped with basic fire prevention equipment such as fire extinguishers, water and shovels. Coordinates contractors will also initiate discussions with the Rattlesnake Fire District staff prior to construction to review emergency procedures, including safety procedures for conducting fire suppression activities near a power line. Now, you may not recall, but this is really all I have found in this that really addresses wildfire mitigations. Do you recall anything else?
No, I do not recall anything else on that.
We now ask the commission to admit this application that Elbert County and Mr. Schroeder approved into the record as hearing exhibit 108.
Mr. Kaufman?
I don't want to object. I have a hard time agreeing to something that's 398 pages long that we haven't had a chance to review. So I don't know what all is in this document. So for Mr. Mansell to expect me to sort of say it's all okay, I just don't know. We've looked at a couple pages here.
The only thing I'm fine providing it for an overnight review. But I will state that in discovery, when we asked for these types of things, council's objection was this is all publicly available, and they did not turn it over. So their understanding is this all publicly available. That's how we got it, and so that's what we're showing here.
And I don't know. This may be to the extent that this is just the application. I just don't know with such a long document that you've shown, a very small portion of.
Yeah, I guess, Mr. Manchin, let me ask you a question. Are you okay limiting the use of this to page 32 and page 45, or are you intending to rely on the whole thing?
I think it'd be appropriate to include the entire document.
All right, let's hold off on admission until you can review it, Mr. Kaufman, and we'll take this up first thing tomorrow.
Mr. Kaufman, if you need an offline copy, Mr. Kaufman, I'm happy to email it to you.
Yeah, however you want to get it to me, that's fine. Or if staff wants to provide it. I think you have my contact info.
Okay, would that work for you, Mr. Kaufman, to review it overnight and take this up first thing
absolutely. I appreciate that. Thank you.
Mr. Mansell, anything else?
No further questions. Thank you. Thank you for your time, sir.
You can take this down. I think we're going to conclude today, but trial staff, I did find the right cross-examination matrix, Mr. Larson, so with apologies. Do you have questions for Commissioner Schroeder tomorrow, or should we start with Commissioner questions?
I think we can start with Commissioner questions, Mr. Chair. I don't think we are going to have anything that was already covered at this point.
Okay. All right. Any final matters before we adjourn for the evening? All right. See everybody at 9 a.m. tomorrow. 9 a.m. tomorrow. Thanks all. Thanks, Commissioner Schroeder.
Thank you.